we can go back to your statement, paragraph 6, the 6th line, the sentence that starts, I will explain. I will explain why this did not sit well with me.
Page 3.
Yes, page 3, paragraph 6. You'll see after you deal with the 3 points, you then say, I refer in particular to the application for authorization. Do you have that?
Yes.
You can read from there.
I refer in particular to the application for authorization of a Section 2813 investigation that I prepared on the 5th of December 2024. I will explain why this did not sit well with me. However, the commissioners must bear in mind that at this point, Advocate Johnson had stated they had made a decision that the matter was to proceed in terms of Section 2813, and that I was to draft the authorization and email it to her on the same day that the referral was handed to me, because she wanted to approve it by Friday, the 6th of December 2024. I deal with this fully later in the statement.
Continue.
On or about the 30th of June 2025, after the Mokwele arrest and the first appearance, I contacted a DPCI officer. I must state I trust this DPCI officer, which is why I contacted him, to inform him that there's a problem at IDAC and that I need to see him and explain and show him the documentation that I had in my possession. I asked if I could if I could do protected disclosure. We agreed to meet on the 2nd of July 2025, where I showed him a prosecutorial memo prepared by me and another prosecutor regarding the matter of General Masiamula and Lieutenant General Kumalo, which I deal with later. He said that he would speak to a colonel at the DPCI and get back to me as to how we were to proceed. The reason that I contacted DPCI is because I had previously, in late April 2025, informed Advocate Santos Manila, the DDPP that I report to, of the discord amongst the team being that of the crime intelligence investigation, and that the investigation procedures were being flouted and that the investigation was sloppy. He replied that he had his own problems. In August 2025, I started collating documents regarding what I considered to be unlawful instructions from Advocate Johnson and Mr. Perumal regarding project diversion. May I proceed?
Ms. Ramsamy, sorry. When Advocate Manilal says he has his own problems, was it about the same issue, the crime intelligence investigation, or?
He had not, although he was on paper as the deputy director, he had not been briefed on the matter, which I do discuss later on in the statement.
The question I'm asking is, when he said he has his own problems, did you understand him to mean about the same subject, the same investigation, or he had his own problems within IDEC? I'm just trying to understand what it is he was.
I understood it to mean that he was not interested in my problems and this project.
I see. Yes, thank you. That answers me. Thank you.
Okay, continue.
On the 8th of August 2025, Advocate Peter Surunya, a Deputy Director of Public Prosecution, came on board the Mokwele and Lushaba cases. He started sending emails and memoranda that accorded with my concerns on how the Mokwele matter was being conducted. Advocate Joyce Swayo and I also approached Advocate Surunya with our concerns. He can confirm this to the Commission. When Advocate Surunya requested to be removed from the Mokwele and Lushaba cases, I was removed from the Mokwele case, and although I was apparently kept on the Lushaba case, I was excluded from the case from September 2025. I also approached another deputy director and showed him all the documentation that were concerning. He stated, "These things will never come to light." In November 2025, after Advocate Johnson testified at the ad hoc committee, I contacted the same officer at the DPCI. I informed him that Advocate Johnson had lied to the ad hoc committee and that I had proof of this. Once the new NDPP, Advocate Matibi, was appointed, I met with the DPCI officer. This would have been around March 2026.
Can I just interject to ask you why it's significant that you mention once the new NDPP was appointed? Did you meet with the DPCI officer?
Because I knew that if I had reported or we had taken these concerns to this then sitting NDPP, nothing would have been done. Advocate Johnson, there would be no repercussions, there would be no corrective measures.
By that you mean Advocate Shamila Batoy?
Correct.
Why would you have formed that opinion?
I was aware of the matter that was discussed with the commission about the sharing of documents, but that was corridor talk, so I wasn't confirmed. But if I may put it frankly, from a prosecutor's point of view that's in the office every day, Advocate Johnson was the blue-eyed girl of Advocate Batoy. She could do no wrong. If needs be, or if the commission so sees fit, if you look at any grievance that was sent about IDAC from the staff members, it was squashed to an extent where people started just resigning. People were applying for posts. I'm an SA. I've been applying for SA posts just to get out of that unit.
And you referred to the sharing of documents. Are you talking about what Mr. Ruloff said, Mr. McLean and Witness O said about the sharing of a docket by Advocate Johnson with General Khan? Is that what you are referring to?
Correct, but at that time, before the testimony, it was just corridor gossip.
Thank you, thank you.
Thank you.
Before you move on to the next paragraph, at the end of that paragraph 9, this is the prosecutors, after you show him documents, the DDPP, and he said these things will never see the light of day. What did you understand by that? That they will be destroyed, they will be suppressed? What exactly did you
That no
understand?
one will ever know that these things were done by Advocate Johnson or at IDAC.
So it would be suppressed?
Correct.
Okay. Paragraph 11 on page 5.
I mention this because I do not want the narrative to be that I am retaliating against Advocate Johnson for making me the scapegoat, or that I am coming forward with this information now that my name has been dragged through the mud.
Then the mandate of IDAC.
IDAC's mandate, as I understand it, is to investigate and where sufficient evidence of criminality is established to prosecute matters of serious, high-profile or complex corruption and related commercial or financial crime. As set out in Section 7 of the NPA Act, the mandate extends to related common law offenses, including fraud, forgery, altering, theft, and any offense involving dishonesty, and related to offenses including contravention of PRECA, POCA, PFMA, and the Local Government Municipal Financial Management Act, the Financial Intelligence Center Act. May I proceed? Where appropriate, IDAC also institutes the resulting criminal proceedings. I've had the benefit of listening to the Commission's engagement with Advocate Johnson regarding the word "or" in Section 7(1), subsection 1, capital A of the NPA Act. My understanding of that IDAC interprets, my understanding is that IDAC interprets this section to mean that IDAC's mandate, insofar as Section 7, subsection 1A is concerned, is to investigate serious corruption or serious commercial or serious financial criminal cases, high-profile corruption or serious commercial or serious financial criminal cases, complex corruption or serious commercial or serious financial criminal cases. In other words, the case may be serious or high-profile or complex. This may be an incorrect understanding, given the debate at the Commission, but this is how I was made to understand IDAC's mandate in terms of Section 7. This may be one of those matters where the Commission's recommendations may assist our office. I will not deal with the structure or the process of how a referral to IDAC is supposed to be handled. Mr. Sissoko, the head of investigations and operations, is best placed to do this. I will deal with the Section 27 referrals based on my personal experience and understanding of the SOP. Case Selection Criteria Directive issued and signed by Advocate Johnson and Mr. Sissoko in October 2024 and in August 2022, respectively.
Okay, the next topic is a referral to IDAC.
In explaining the Section 27 referral process, I must set out the following. At the time of the Adams referral, the bulk of IDAC's cases were either existing cases from other units, such as the Specialized Commercial Crime Unit, or cases emanating from the reports of commissions of inquiry, such as the State Capture Commission or the Nugent Commission. I am only aware of one other 27 referral since I joined IDAC in March 2023. This related to a matter involving a high-profile individual. I have provided some documents relating to this matter in the Commission to demonstrate the difference between how Section 27 referral was dealt, this Section 27 referral was dealt with, and how the Crime Intelligence Section 27 referral was dealt with. This was and still is a standard operating procedure referred to as the IDAC Operation Manual, issued and signed by Advocate Johnson and Mr. Matthew Sissoko, the head of investigation, on the 16th of October 2024, which I have also provided.
You must just raise your voice again and...
Sorry.
Yes.
If I may just have a bit of water. There was and still is a standard operating procedure referred to as the IDAC Operation Manual, issued and signed by Advocate Johnson and Mr. Matthew Sissoko, the head of investigations, on the 16th of October 2024, which I have also provided to the Commission. In addition to the SOPs, Advocate Johnson would from time to time issue additional directives. Prior to the issuing of the SOPs, Advocate Johnson and Mr. Sissoko also issued a case selection criteria manual of sorts, which set out in detail the process to be followed in selecting cases to be investigated by IDAC. I have also provided this document. IDAC operates on the principle of prosecution-led investigations, which means that every matter is led by a senior prosecutor at the level of Deputy Director of Public Prosecution, a DDPP, working within a multidisciplinary team of prosecutors, criminal investigators, financial investigators, and data analysts. May I just, on a side note, prosecution-led investigations, if correctly done, is a brilliant method. But as it stands, it is left open to manipulation of targets. It is so easy at this point of where we are as IDAC, to manipulate the statements, who the suspects are, how the investigation is to proceed, who witnesses will be, what these witnesses will say, how they will say it, what evidence is included, what evidence is not included. And it has, as I will later show, been manipulated by and used by Advocate Johnson and Mr. Perumal.
When you say at this stage, it is very easy for this to happen, must we understand that to mean this is not necessarily about the structure, it's about personalities, or what makes it easy for this to happen?
There's no checks and balances.
You need to raise your voice.
Sorry. There's no checks and balances. Prosecution led with proper checks and balances. For the purpose for which IDAC was established, would excel in recovering money for Kara, successful prosecutions for corruption. As it stands, and I'm not saying all the cases, I mean, we've got some very good prosecutors, and we've got some very good, honest working people in IDAC. My reason for bringing this is, because there's no checks and balances, we are where we are today. I'm giving evidence today because of the manipulation of Section 20 and the prosecution led.
Do you, but only if you've applied your mind to it and are able to answer, do you have in mind the sort of checks and balances that would address the shortcomings?
The SOPs speak to a panel that includes investigation, prosecution, and other multidisciplinaries that are housed within IDAC. And that panel was supposed to make decisions collectively using different knowledge, skill sets. It's not applied. The checks and balances are who checks that? Where's the authority that checks that we are complying?
There's that old Latin saying, I will not say it in Latin, who will guard the guards?
Yes.
It sounds like that's basically what you are saying.
Yes, that is what I am saying, because if you look at the structure of a general prosecution, OCC is prosecution guided. There are so many checks and balances in place to prevent this very thing that we are talking about today. Am I too soft? Sorry. This very thing that we are talking about today is prevented in that unit because there's checks and balances.
And so just to be sure that I understand, are you saying let me loosely call it the broader NPA, the NPA outside of IDAC, are you saying these checks and balances do exist there? Is that what you are saying? Or
Correct.
All right.
Can I just ask slightly different, the same question? Are you saying there are no checks and balances because people do not adhere to the operations manual which prescribes or which sets out that there will be a team which is constituted in the way that you have described? Is that where the comment comes from? There's no adherence to that? And if the answer is yes, it seems to me then you're saying if we adhered, we do have something that's supposed to guide us, we just don't comply with it. And if we complied with it and adhered to it, then what is happening now would not happen because we do have written down checks and balances. I'm just trying to understand whether there's no provision, adequate provision or there is provision, it's just not complied with?
If I may just, if I'm a practical situation of within the office. So when you do the investigation plan and the taskings and the deputy director is in charge of, the former head of IDAC would, so if I had a problem with Advocate Ncube, I could go and gossip. I could really just, our office was run on gossip. You would be called into the office on gossip. But I could go and gossip about Advocate Ncube and say, Advocate Ncube doesn't know what she's doing, she's confusing the processes, and then the next meeting, Advocate Johnson is at the meeting, and what I said is golden, but the correct way that Advocate Ncube is asking for is out the door. So, in as much as we've got a structural basis, the head constantly would interfere and deviate from that.
It's not a question, it sounds from what you're saying, and please just clarify for me, it sounds like it's not a question of something must still be invented that will provide the checks and balances, that would obviate what you're describing now, but rather you do have the tool on paper if only we all complied with it and strictly, then this concern or this complaint and its consequence would not happen.
Correct. Also, you must understand, until March 2026, none of this could be reported, because who do we report it to? Now that Advocate Mutibi is there, we are a little bit braver to come forward about these things that we were being instructed to do.
Does I don't know much about it other than what has been reported in the media. You know better and much more about it. Does the office, the existence of the office and now the appointment of the office of the IDEC judge, I'm going to call him that, in its mandate, and its written mandate, I'm not talking about informalities, I'm talking about formal mandate. Does that address what you're raising? If there is concern about matters that relate to the ID, or for that matter, even the NDPP, because there's now this great friendship between the ID and NDPP. Does the mandate of the judge include that you can escalate matters that you're concerned about? You could escalate them to that office?
To an extent.
Okay.
To an extent. But it will become clearer
As you can.
as I go on.
Okay, thank you.
Ms. Ramsamy, I don't want to keep reminding you to raise your voice.
I'm sorry. I'm sorry.
Can we then go to the next topic, the investigation process in respect of a Section 27 referral?
The investigation process is supposed to follow a sequence as set out in the SOPs in the Case Selection Criteria Directive. This is how the process is supposed to work, but even in other Section 27 referral, the other Section 27 referral I deal with later, there was no strict compliance with this process. Once again, this is how the process ought to be implemented, but it is not always done this way. Having said that, in my view, the failure to adhere strictly to the SOP does not mean that the process is irregular. As long as the process complies in substance, it would not be irregular. I will explain later when I deal with my first Section 27 referral. Since joining IDAC, I have been designated to a number of multidisciplinary investigations and prosecution project teams dealing with serious, high-profile and complex corruption, commercial and financial crime matters. In that capacity, my functions have included assessing a Section 27 referral for the compliance with the IDAC mandate, formulating and executing the prosecution strategy, working with investigators from the inception of an investigation, and guiding matters from intake through to enrollment. Given that my experience of dealing with the Section 27 referral, other than the crime intelligence referral, is limited to only one prior referral, it would be easier for me to explain, with reference to my prior experience, how a Section 27 referral ought to be dealt with in practice. The irregularities of the crime intelligence referral will become abundantly clear to the Commission. In July 2023, I received a meeting invite from Advocate Johnson. The other attendees were another state advocate, Mr. Dylan Perumal, Chief Investigator, Mr., if that may be corrected, it's Mr. Tamane Benang. Investigator, Mr. Mansa Rapesu, Senior Investigator, and Mr. Sissoko, Head of Investigations. At the meeting, Advocate Johnson stated that she had received a Section 27 referral and that had held a consultation with the deponent and the deponent's legal representative. Advocate Johnson briefed us on the averments and then instructed the team that no one was to know that we were handling the matter, owing to the sensitivity of the information and of the implicated person or persons. Advocate Johnson then instructed the prosecutors as follows, which I might add are consistent with the case selection criteria and SOP. My underlining of certain portions of the subparagraphs that follow is deliberate for the reason that will become clear later. We were to make copies of the statement, the prosecutor and myself, that she had handed to us and return the original to her office. The prosecutors were to interrogate the affidavit and decide whether it fell within the mandate of ID. Once the prosecutors had reached consensus, we were to draft a certificate of mandate. If our assessment was that the case did not fall within the IDAC's mandate, we were to compile a comprehensive memorandum detailing this finding. Once the certificate of mandate was signed, the prosecutors were to attend to drafting the application of authorization of a Section 2813 investigation. And once authorization was signed, we were to consult with the investigators and draft an investigation plan. Should the investigation yield evidence of criminality, we had to motivate for a Section 28(1) authorization. This motivation had to be accompanied by an evidential report prepared by the prosecutors, which is a full and detailed summary of the facts and evidence in each statement obtained. And should the investigation show that no criminality could be proven, or that there was no prima facie case, the prosecutors would prepare a detailed memorandum setting out a summary of each statement and a detailed submission as to why there was no prima facie case, as I will illustrate later in the statement. This process was followed in this regard. I refer the Commission to the following documents, which I ask not to be displayed, or if displayed, to be redacted.
At this point, Commissioners, if we can go to page 93 of file 10, this can be displayed because it makes no reference to the matter itself, but it is an example of the consideration of mandate that Ms. Ramsamy is testifying to. So that's page 93 of file 10. Do you have it?
Thank you.
This will then correspond with your paragraph 23.1 of your statement.
Correct.
Okay, so maybe if you can just take us through the document.
Myself and the other advocate that had been allocated to the matter. And I might add at this point, when we were given this 27 referral, we were given a week to interrogate the evidence contained in the affidavit referral. We then drafted this, indicating that we had found sufficient evidence that it did fall within the IDAC mandate, not only under high-profile individual, but also serious corruption.
Okay, thank you. So we can go back to your statement 23.1.
Maybe before you do that, the page 93 is quite scanty. Is that all you say? You have an introduction. I'm not asking you to speak to that specific referral. I just want to get a sense of what information, in fact, gets covered in this kind of document. What do you discuss?
There was a verbal briefing about the allegations. And then once we received we did a comprehensive application for 2830. When I say comprehensive, we also included a 19-page summary of the evidence that was contained to confirm our mandate and our application for the 2830. And
So you set out what the matter is about,
Correct.
what you have found, what you have to inform a decision on the recommendation that you're making.
correct.
Okay.
And so this would be the first page. This is our recommendation having regard to what had been provided to us, and then you include your summary, the 19-pager.
Correct.
Okay.
I unfortunately cannot give that to the commission.
No, I understand. I just wanted to have a sense of the decision maker, because this on its own is not very helpful at page 93. It doesn't tell you what the decision maker has in front of them to exercise the discretion whether to accept or not accept the recommendation. Thank you.
And then just still on that document, we have, at B, it says recommendation. This matter falls within the mandate. That's your recommendation with the other prosecutor. And it then goes to Mr. Sesoko and Advocate Johnson.
Correct.
For their recommendation.
Correct.
Or approval.
So they
Oh, he recommends and she must approve.
correct. It's so that it's what I spoke of the previous way we dealt with checks and balances.
Okay. And then at 23.2 of your statement, you deal with the application for authorization for Section 2813. So that happens after Advocate Johnson confirms that she approves that it falls within the mandate, after you submit this document, the consideration memo of mandate, and the summary, and then she would ask you, who makes the decision that there must be an application for 2813?
After the report and the certificate, we would then receive an email or a WhatsApp from the PA indicating that please come and collect your certificate, and at that point we'd be informed, proceed with drafting a 2813. It was not a matter of us just bombarding them with the applications. We had to get permission for each step.
Okay, let's try and finish this section and before tea. Paragraph 24.
Thereafter, a meeting with the investigators took place and an investigation plan was drafted. This is referred to as a prosecutorial plan. Once the investigation was completed, I drafted what is referred to as an evidential report. This report provides a detailed summary of the evidence contained in each statement obtained, how the individual statements or collective evidence is linked to the elements of the offense. At some point, the state advocate was removed by Advocate Johnson and a deputy director was allocated to the matter. We drafted and submitted a request for a Section 28(1) to be approved. And upon approval of the request, the Section 28(1) was submitted and signed by Advocate Johnson. The process of registering a docket and enrollment then followed.
Thank you, Chair. Would this be a convenient time to take the tea adjournment?
Yes, let's adjourn and resume at 11:30.
Thank you.
1. Good morning again. It's 29 minutes past. We are ready to resume. Please make sure that your devices are quiet. Thank you.
Can you switch on your microphones?
On.
Thank you.
On the morning of the 3rd of December 2024, the office staff received notification of a staff meeting scheduled for Friday, 6 December 2025.
24.
On the morning of 4 December 2024, an investigator working on another case with me sent an email to Advocate Johnson informing her that we, including Friday. In her email, she said, "I need to see you tomorrow." Us, which meant is, a product I need you to compile for my office to be submitted by Friday. I responded that I would avail myself of the briefing and the other prosecutor would attend court that Friday.
If we can just pause there, that correspondence appears at page 100 to 101, and the email from Advocate Johnson specifically telling you that she needs you for tomorrow is at the top of page 100, but it starts on 99. The first line is cut off, but it says, "Drew, can Tillis carry on without you on Friday?" That's the cut-off part at the bottom of 99 and top of page 100. And then on page 100, there's the "I need to see you tomorrow," and there us, which is a product I need you to compile for my office to be submitted on Friday. That's the email you're referring to.
Correct.
And you then respond on page 99, "Morning, Advocate Johnson. Apologies for the late reply. I am in court. Noted, Advocate Johnson. I will avail myself tomorrow for briefing, and on Friday, Advocate will attend to the High Court postponement."
Correct.
Okay. So we can go back to your statement, paragraph 29.
The next morning, the 5th of December 2024, at 8 a.m., I went to Advocate Johnson's office per her instructions the previous day. When I arrived at her office, she had a gray document bag with a zip, and she told me that it contained a highly sensitive Section 27 referral affidavit. She told me that they had decided that the matter will be investigated. She did not say who they were, and I did not ask. I assumed that she would be referring to herself and Mr. Sissoko, given my previous experience. I later learned that Mr. Sissoko had no knowledge of this matter. Returning to the document bag, it also contained a pinkish purple page from a notepad with names of people in Advocate Johnson's handwriting. She told me that these are the suspects Chief and I discussed are to be included in the Section 2813. By Chief, she meant Mr. Perumal. Advocate Johnson handed me the bag and gave me the following instructions. Again, my underlining is deliberate. I must take the content of the bag and prepare an application for authorization of a Section 2813 investigation. The names on the notepad were the names of the people who must be listed as the suspects in the application for the 2813 investigation authorization. She gave me the names of the IDAC members who would form part of the team on this matter in order for me to include it in the application. She indicated that it would be Advocate Manilal as the DPP, Mr. Perumal, Chief Investigator, Mr. Rapesu, Lead Investigator, Mr. Padiachi, Senior Investigator, Mr. Venon Vessels, Chief Financial Investigator, and me, Prosecutor. Advocate Johnson said that she needed a DDPP on the matter for the purposes of authorization, but that she would supervise the matter. I must not make copies of Section 27, the 27 referral affidavit, 30.5, I am allowed to make notes regarding the Section 27 referral affidavit. 30.6, I must not show the Section 27 referral affidavit to anyone due to the sensitivity of the matter. Once I have prepared the application, I must email the application to her as a matter of urgency, and I must then return the contents of the bag to her.
Let me just make a comment here. When Mr. Padiachi testified and said that he never had sight of the Section 27 referral affidavit, I suggested to him that that was very hard to believe, because what would he have investigated if he did not have what was in effect the source document? What you've just said now appears to vindicate what he said.
Not so soon, Chair.
Oh.
She'll get to it.
Oh, spoke too
But
soon.
it's an
Spoke too soon.
it's an apt observation, which is why she deals with it.
All right, okay,
Thank you,
thank you,
Chair.
thank you.
Can I just, because we have not seen the Section 27 affidavit you are referring to. You say there was this purple pinkish notepad and it had names of people.
Correct.
When you looked at that affidavit, did the names that were on the purple notepad also appear in that affidavit you were looking at that you were told not to make copies of?
No, Commissioner.
Thank you.
When she gave you the list of names, did she say where she got that list from?
Yes, Commissioner, I do deal with it in paragraph 30, on page 30. She told me that these are the suspects Chief and I discussed are to be included in the Section 2813, Chief being Mr. Perumal.
The more direct question perhaps then, when she testified, you were following, she didn't remember where she got this list from. She thought it came from you, and then she called, she came back to report that she called you, and you said to her on that call that you said she told you when she gave you the list that she got the list from Chief Perumal. Is that correct? That happened on that day that she gave you the list?
No, no, Chair. Sorry, Commissioner. Commissioner, the page was her handwriting. Her handwriting is very distinctive. And it was a pink purplish page with notes that she would usually, or a notepad that she would usually keep in her office. And she had clearly stated to me, these are the names Chief and I decided, but it was her handwriting.
Okay, second question. When she called you now, as she was testifying here, when she called you, if she did call you, did she call you?
Correct.
To ask about the list?
Yes, correct.
Okay. Did you say to her that, but when you gave me the list, you told me that it came from Chief Perumal? Did you say that to her?
Commissioner Paloi, she's going to deal with it in detail because there's some corroborating evidence that she wants to deal with, but specifically dealing with your question.
Okay, I'm happy to leave it. Thank you.
I think we're now at paragraph 31.
31.
But just before that, we do have the application that you submitted to Advocate Johnson, and you refer to the names that were on that page that she had given you. That should be the suspects. If we go to file 10, page 108, if you could just let us know, because those are the names that's referenced in your application. So if we can start on 106, that is the application that you sent to Advocate Johnson, correct, for
Correct.
authorization?
Correct.
We'll deal with the email correspondence evidencing that you had sent it to her. And then on page 108, at paragraph 3, names of subjects and entities forming the subject matter of the investigation, but are not limited to, and there are names there, and an automotive engineer. Are those the names that was on the page?
Correct, because the 27 referral that I had sight of, a lot of these names didn't correlate with that 27. So I personally don't know. I can honestly tell you, Chair, even during the investigation portions of it, 3.11, no feature. 3.9, also no feature. 3.12, I will explain as I go on as to how that name came about, but it wasn't in the referral.
Okay. So then let's go back to your statement, paragraph 31.
Advocate Johnson told me that she needed the application urgently. Because she wants to approve the Section 2813 investigation by Friday, 6 December 2024. She did not explain the urgency. I requested that I be allowed to draft the application when I got home later that day, because I had to be in High Court in the morning for another matter. She said it was fine as long as she received it that evening. I assumed that when Advocate Johnson stated they decided that there will be an investigation, that she had already received a consideration of mandate memo from a senior prosecutor or DDPP, as this was done in the other Section 27 referral matter. The matter immediately did not sit well with me. In my limited experience, the prosecutors who prepared the consideration of mandate memo, ought to be the prosecutors preparing the application for Section 2813. Investigation authorization. But since the instruction came directly from Advocate Johnson, and she had already told me that the decision had been made, and that she wanted to approve the Section 2813 the next day, I complied with her instructions. Later that afternoon, I went about preparing the application. When I read the Section 27 affidavit that Advocate Johnson gave me, I became very concerned about the merits of the application. I have to deviate before I deal with the application itself. To deal with the contents of the Section 27 referral affidavit that I received from Advocate Johnson on the 25th of December 2024.
The 5th.
Sorry, 5th of December 2024.
Okay, then the subtopic, the Section 27 referral affidavit.
When Mr. Padiachi testified before the commission, a document was flighted, and it was identified as the Section 27 referral affidavit of Mr. Fadil Adams. This document is contained at page 512 to 516 of the IDAC exhibit bundle. When I saw this document, my heart dropped to my stomach, because this was not the 27 referral affidavit that Advocate Johnson gave me on the 5th of December 2024. In fact, I saw this document for the first time when it was flighted at the commission. I initially thought I was mistaken. I then contacted Mr. Rapeso to discuss with him. He confirmed that the Section 27 affidavit that was flighted at the commission was not the Section 27 affidavit I had shown him on the morning of the 6th of December 2024. I will return to why I showed the Section 27 affidavit to Mr. Rapeso in violation of Advocate Johnson's instructions not to show the affidavit to anyone. I have not seen the Section 27 affidavit after the 6th of December 2024. After I had returned it to Advocate Johnson. What I recall of its contents is based on my memory, but as the commission will see, there are certain contemporaneous recordials by me that somewhat corroborate my recollection of the contents of the Section 27 affidavit. For convenience, I will deal with the Section 27 affidavit that I was given on the 5th of December 2024 compared to the Section 27 affidavit that was flighted before the commission in tabular form. Page 16.
So what we then have is a table with, on the left, the Section 27 affidavit that was given to you on the 5th of December versus on the right, the Section 27 affidavit that was flighted at the Commission, which is 512 to 516 of File 2 of the exhibit bundle.
Correct.
So at number 1, you can start there.
Thank you. The Section 27 affidavit seen on the 5th of December 2024 referred to Orlando Kaz. I am not going to read it into the record, and a Valeria Kaz. The Section 27 affidavit flighted at the Commission, page 512 to 516, listed Cape Town Kaz dockets. 2. Major General Madondo failing a polygraph test while seeking security clearance. Although,
Maybe for the record, you're unfortunately going to have to repeat the heading.
Okay, not a problem.
I think you can just say the section affidavit you saw, then say that is what it contained, and then say the flighted one, this is what.
noted. The one that I saw, Major General Madondo failing a polygraph test while seeking security clearance was prominent or noted. On the one that was flighted, although vetting is mentioned, it is in a different context and no mention is made of a polygraph test. The one that I had seen, number 3, allegations of procurement irregularities within crime intelligence regarding the procurement of a forklift. On the one flighted, there's no mention of a forklift. Number 4, on the one that I had seen, multiple allegations of alleged criminal conduct by the political killings task team, such as procurement of vehicles, excessive budget for laundry using the Secret Service account. This is not mentioned on the 27 flighted. Number 5, vehicles that were procured for the PKTT being used by the former Minister of Police, Mr. Cele, for his personal use. This is also not on the one that is flighted. Number 6, purchasing of hotels, lodges, or properties using the Secret Service account, also not mentioned on the one flighted.
Okay. Paragraph 37.
The commissioners will hear from Mr. Rapesu as to his recollection of the contents of the Section 27 affidavit that I showed him on the 6th of December and whether his recollection accords with mine. Paragraph 8. 38. In corroboration of my recollection of what was contained in the Section 27 affidavit that I saw on the 5th of December 2024, I refer the Commission to a written request for case dockets that Advocate Johnson instructed me to prepare and addressed to Major General Mbuso Kumalo. The letter is dated 6 December 2024 and was signed by Advocate Johnson on the same day. The request was based on dockets referred to in the Section 27 affidavit.
Can you just pause there? We want to refer the commissioners to that. It's on page 111 of file 10. And this is the letter that you were prepared on Advocate Johnson's instruction requesting the dockets on the 6th of December 2024 from Major General Mbuso Kumalo. And at paragraph 2 is the list of the case number, the dockets that you were requesting.
Correct.
And they are Valeria, Orlando.
Correct.
And you then say that is what was in the Section 27 referral affidavit that you saw.
Correct.
Okay. Now, if we can then go to file 2, page 512. Do you Do you have it?
Almost there.
Okay.
Yes.
That is the section 27 affidavit that we refer to as the flighted affidavit, section 27 affidavit. And you'll see in paragraph 1, it says, in my capacity as a member of parliament for the Republic of South Africa, I first opened 3 cases in Cape Town Police Station with case numbers Cape Town, and it gives the case numbers expressly. And there is no case number for the Orlando or the Valeria, but there is a reference to those case dockets, and you'll find that on page 515, paragraph 8. A few days after I opened the 3 cases at Cape Town Police Station, I decided to go to Gauteng, and I went to Orlando Police Station where I opened another 3 cases based on the 3 cases I opened in Cape Town, but it doesn't give the case numbers, the CAS numbers.
Correct.
And your point is that you could have only prepared the request to Major General Mbuso Kumalo, specifically mentioning the Valeria and Orlando case numbers because you had the section 27 affidavit that expressly referred to those case numbers.
Correct. If I may also clarify another aspect. At this time, I had no knowledge of any emails that had taken place between Chief of Staff Cedric Nkabinde and Advocate Johnson, or any emails between Police Minister Senzo Mkhunu and Advocate Johnson. So what I worked off for this request from Lieutenant General Mbuso could only have come from the 27 referral.
I assume you did not have any discussion with Chief Perumal, because we understood from Advocate Johnson that he's the one who went to Mr. Adams to obtain the affidavit. So you did not have any discussion with him about the Orlando cases and case numbers?
No, the communication I had with Mr. Perumal on that day was I needed the details of Lieutenant General. I didn't even know his name was Mbuso.
Yeah. So he could not have given
He
you
could
the
not have
Orlando
given,
case
and
numbers.
everybody was rushing because after the meeting he was leaving to the airport to go back home, which I deal with later on. But the only information that I requested from Mr. Perumal was who do I address, like, you know, the full title and the email address, at which point Mr. Perumal went outside the office because we were open plan, but we were in his office at the time. He went outside, he said, let me call Charity, that being General Charity Matlo, to get the details, and then he had come back to me with the details. And then he spoke to Mr. Rapesu, and he left.
Okay, so we can go back to your you say the request was based on the dockets referred to in the section 27 affidavit.
I could only have gotten the CAS numbers from the section 27 affidavit because on the 6th of December 2024, I had nothing more than the section 27 affidavit and Advocate Johnson's handwritten notes with the names of the suspect. While reference is made to the Orlando docket in the section 27 that affidavit flighted at the commission, the CAS numbers do not appear on the affidavit. The section 27 referral flighted at the commission could not and is not the 27 referral affidavit that I used to prepare the application for section 2813 investigations. Paragraph 39. The reason both Advocate Johnson and Mr. Padiachi have struggled to marry the allegations contained in the section 27 affidavit flighted at the commission with the contents of the section 2813 authorization is because the section 28 affidavit, or 27 affidavit flighted before this commission is not the section 27 affidavit that I used to prepare the section 2813 application, and which formed the basis for the authorization. Paragraph 40. The allegations about the PKTT featured prominently in Mr. Adams' Section 27 affidavit, that the one flighted makes no mention of the PKTT. The allegations of Brigadier Mukwele appointed was more a throwaway allegation on the Section 27 affidavit that I saw. My draft Section 2713, paragraph 41.
2813.
Paragraph 41, my draft is also corroboration of the version of the Section 27 referral affidavit that I saw on the 5th of December 2024 when I drafted the application, 41.1. In paragraph 1.3 of the draft, I referred to the allegations of unlawful actions regarding the vetting and polygraph testing perpetuated by crime intelligence officials.
Can we just pause there and refer the commissioners? It's on page 107 of file 10. That is the draft application, or your application. And you were referring us to paragraph 1.3, the allegations about vetting and polygraph testing.
Correct.
Okay, you can continue in your statement.
Thank you. The allegations of unlawful actions regarding vetting and polygraph testing is not contained in the flighted Section 27 referral. I could only have gotten the allegations from the Section 27 referral because at that stage, we had not even requested the dockets. Paragraph 41.2. The Section 27 referral affidavit I considered contained allegations of procurement irregularities regarding the procurement of a forklift by crime intelligence and procurement of vehicles for the PKTT. Hence, the reference to awarding tenders in the Section 2813 application and authorization.
And that is on page 107, file 10, paragraph 1.7, fraud and corruption pertaining to awarding of tenders and or contracts involving SAPs and or circumventing of procurement processes.
Correct.
Okay, then we can go to the next subtopic, Mr. Perumal's attempt to scapegoat me regarding the Section 27 affidavit.
Paragraph 42. On the 9th of October 2025, I was contacted by Ms. Innocent Sukukane, personal assistant to Advocate Johnson. She informed me that she was told that Mr. Perumal had called me that same day regarding the whereabouts of the original Section 27 referral affidavit. She said that I had told Mr. Perumal that I was tasked with the safekeeping of the Section 27 referral affidavit and that I could not chase the Section 27 referral affidavit. Paragraph 43. If I recall correctly, in September 2025 or early October 2025, the accused persons in the Mukwele matter had made numerous requests for the Section 27 referral. I want to say that Advocate Johnson and Mr. Perumal were struggling to find the Section 27 referral affidavit and perhaps thought I had the affidavit. But I cannot say, there's a word missing. I want to genuinely say.
So it should read, I want to genuinely say that Advocate Johnson and Mr. Perumal. Okay.
Mr. Perumal was struggling to find the Section 27 referral affidavit and perhaps thought that I had the affidavit. But I cannot say that because what I suspect is that Advocate Johnson and or Mr. Perumal did not want to disclose the Section 27 referral affidavit to the accused persons in the Mukwele matter and needed a reason as to why it could not be produced. My suspicion is that the flighted Section 27 referral affidavit was produced at that stage and after Lieutenant General Mkonazi's press briefing on the 6th of July 2025, where he stated that IDAC was investigating the PKTT.
When you say it was produced on that day, you mean created?
Created.
Okay, thank you.
Thank you, Commissioner.
But to be more precise, you say at that stage, not at that day.
At that stage, yes.
So I understand you to mean that it must be after September or early October 2025. Because if it existed in early October, the flighted Section 27 would have been provided to the accused. So it must mean it did not exist when the accused were asking for it.
Correct. The one that is flighted
The
did
one
not
that is
execute,
flighted, yes.
was not, yes, created by then. I do not think it is a coincidence that the flighted Section 27 referral affidavit makes no reference to the PKTT, whereas the version I saw in December 2024 does. And now there is no record of that version, other than the original that I returned to Advocate Johnson on the 6th of December 2024, which was not produced, and in respect of which Mr. Perumal tried to create the narrative that I had misplaced the original. I was concerned that I was being blamed for something I had no knowledge of. I addressed an email to Advocate Johnson to set out the events that transpired on the 5th of December 2024 and thereafter regarding the Section 27 referral affidavit. I have provided the email to the Commission. My reference to 5 of December 2025 in the email is to be corrected, and it should be 5th December 2024. I'm dyslexic, I apologize.
We can go to that letter now, the email that you sent, and that is in file 10 on page 402. You'll have to read the letter to us, the email,
Can
the
I
entire
have the
email.
reference again, please? Sorry. Reference.
Page 402 of file 10.
Thank you.
Let me know when you're there. Do you have it?
I do.
It's an email from you on 9 October 2025, 1347, addressed to Advocate Johnson, Mr. Perumal, Mr. Sesoko, Mr. Tlale. Who is Mr. Tlale?
He's the project manager.
And then that is Innocent is the assistant.
Correct.
Advocate Johnson's assistant. And the subject is Section 27 referral, F. Adams.
Correct.
You can read it.
Good day, Advocate Johnson. I was contacted by INO in respect of, 1, that I was contacted by Mr. Perumal today regarding the above referral, and that I indicated you told me to keep it safe and that I cannot trace it. Mr. Perumal did not contact me today. Mr. Shlale contacted me this morning, and I explained to him as follows, 1.1. On the morning of the 5th of December 2025, but it should read 2024, at 8 a.m., while in your office, you gave me a gray document bag folder with a zip which contained the 27 affidavit referral and piece of note paper with your handwriting. I asked to attend to the necessary after court from home, which I did, and emailed you that evening, 1.2.
Sorry, can you just raise your voice and...
Sorry.
Okay. 1.2?
1.2, your instructions regarding the folder was that return it to your office the next day, and no copies of the documents were to be made. Because the gray document bag was conspicuous, I put it in a large brown envelope and returned same to your office before the staff meeting on the 6th of December 2024. Once again, I apologize. On the 10th of June 2025, in your office, where a meeting was being held with myself, Mr. Sissoko, Mr. Perumal, Mr. Padiachi, Mr. Mlambo, and Mr. Charles, I indicated that we needed the documents in the folder. At that point, we were all packing to move offices. You indicated that I should text you the following day and you would look for it through the many boxes. 1.5. On the 11th of June, 2025, I attach a screenshot. I contacted Mr. Perumal indicating that we would only need the folder in 3 or 4 weeks should I trouble the ID to look for the folder, to which he replied, it can wait. Paragraph 2, I wish to state, I did not retain possession of the original Section 27 affidavit referral, nor any copies thereof. As instructed, I returned same to your office on the same day after receiving it. 2.2, I did not have any communication with Mr. Perumal today. Our last communication was on the 18th of September, 2025 via WhatsApp text. Thus, I could not have told him that I was asked to keep it safe and I misplaced it. 2.3, I was contacted by Mr. Shlale today, earlier this morning, and stated to him exactly what I have stated above. Kind regards, Trishanta Ramsamy.
Okay, can we then go back to your statement? We are at paragraph 45.
Thank you. Later the same day, at 3:04 p.m., Advocate Johnson responded to my email via WhatsApp. In the message, she accepted that she may have been mistaken about the Section 27 referral affidavit. She said she would look in her office the following day. If she disagreed with the contents of my email, she would have surely responded either directly to the email or via WhatsApp.
Can I just interrupt you here? If what you are saying is correct, and it goes back to the point Chair made earlier, from January when the investigation started and the summonses were being issued, January 2025, until the arrests in June, all the way until September, October 2025, nobody at IDEC knew where the original Section 27 affidavit was.
If Commissioner...
So how did they conduct the investigation leading to people being arrested and charged if nobody knew? If they last saw it, according to the inquiries that are being made to you, if they last saw it when they handed it to you and you handed it back?
That's a very good question. How did they do it? Because if the commissioners have to marry what has transpired with the arrests versus what is contained in that 27, there's great discrepancies. It's devastating. And in part 2 within this statement and in part 2, I will demonstrate how the commission has been hoodwinked.
Or lied to. I'm not saying we have concluded that we've been lied to, but I'm just saying perhaps the lied to is an appropriate, stronger word in the context.
I'm trying to be polite.
Thank you. May I ask you to read the last sentence of paragraph 5? You did not read the have, if I'm not mistaken. And
Paragraph 5 in the...
45, the last sentence starting if she.
Thank you. If she disagreed with the contents of my email, she would surely have responded either directly to the email or via WhatsApp.
Okay, we're just trying to locate the WhatsApp screenshot. I know that it had been provided to us where Advocate Johnson responds, and it should be in the exhibit bundle, but for some reason it's not in the electronic version, but we'll come back to it later. But we have seen it. Can we then go to the next topic, subtopic, explanation of the names of suspects in the Section 2813 authorization?
Paragraph 46. Another issue that warrants special mention is the issue raised by the Commission about the lack of substantiation of the names of the suspects listed in the Section 2813 authorization, as indicated when Advocate Johnson instructed me to prepare the application for the Section 2813 authorization. She gave me a list of suspects' names on the pink, purple notepad page. This has consistently been my version. Paragraph 47. On the 22nd of July, 2026.
It's the 22nd, yes, so there's a correction, yes. The statement says 21, but it was 22.
The Commission asked Advocate Johnson to explain the source relied upon for the names that appeared in the suspects on the Section 2813 authorization. As stated earlier, I got the names from Advocate Johnson, together with the Section 27 referral affidavit. Advocate Johnson undertook to make inquiries. Later that day, at approximately 3:10, while I was consulting with the Commission's evidence leader, Advocate Johnson called me, and the call was recorded. The Commission is in possession of the recording because Advocate Johnson had already scapegoated me in her testimony before the Commission, and I felt I needed to record our conversation. In the recording, I explained how the names ended up in the Section 2813 authorization based on the names she gave me. At the stage of the recording,
At the start of the recording, Advocate Johnson
made a startling remark that we gotta figure out how you don't go. In other words, find a way for me not to testify before the Commission. I have no objection to the recording being played.
Chair, Commissioners, at this stage, we want to play that recording for you. It is approximately 12 minutes. We have tried to only deal with what we consider to be important, but actually all of it is important. And there may be a point that we do cut it where it has nothing to do with the subject matter. It deals with three aspects. Number one, what the witness had just indicated now, a comment that they must find a way not for her to testify before the Commission. The second...
Her being...
Her being the witness before you now. The second issue is a debate or an exchange about the names, how the names came about in the 2813. And then there is some criticism that Advocate Johnson makes towards the Commission and the process that the Commission is following, which we don't think is relevant, but it may be that we have to play the entire recording so that it's not suggested that we are withholding anything insofar as the recording is concerned, Chair. But
and I believe that all three of us have very thick skins.
I believe so too, Chair. Thank you. So if you just indulge us, we'll be listening to it for the next 10 to 12 minutes. Sorry, Advocate Ramsamy, if you can switch off your microphone.
Hi, Advocate Johnson. Hello.
How are you?
Fine, and you?
Well, they put me through the paces for the Section 2813 on the
On
on the
diversion.
Khumalo matter. Yeah,
Okay. I haven't been watching. I've been so busy.
yeah. Don't worry, I think they're going to call you.
Oh God.
I'll come and tell you why.
Mm.
We'll have to figure out how you don't go. Okay, so they said to me, I must tell them step by step. I said, I get the 2813. Usually we give it to a team. Santosh is the deputy, but I give it to Drew.
Yeah.
You use it to compile a section 2813.
Mm.
Now they're saying when they look at the 2813,
Yeah.
must just check, the annexure that has all the names of the people, annexure A,
Mhm.
it has all the suspects. Now
Yeah,
they're
yeah,
saying
yeah.
when you look at the 2813,
Mm-hmm.
you could only really make out Kumalo, maybe Madondo and Lushaba.
Yeah.
Where did you get all the other names from?
That page that you gave me, the names were on that page that you gave me. The one in the folder. The one in the handwriting on the pink purple page.
Where would we have got those names from?
I don't know, you gave it to me on the morning just before I rushed to court. You gave me the 27 referral and the names on the handwritten page.
Because they are asking me where you got the names from, and I honestly am saying, I'm not sure. Because I can't remember to share for me. I can't remember either.
No, I remember distinctly because that's why I also put it in my email where I received the 27 referral and I received that piece of paper with handwriting and it was the suspects that was written on there. And you explained to me that the suspects was after Dylan had consulted with Fadil. That's how the list came about.
So Dylan would have consulted Fadil before you did the 20.
Before I did the 28, yeah, before I even received the 27, the list was compiled on that page with the handwriting, and you had indicated that Fadil and Dylan had consulted, and that's where it came from.
I'm going to have to speak to Dylan. He can't remember half the things.
But it's on my email.
Because I say I've now abused my power by authorizing other people's names that are there.
I don't know what to say, Mama, because I specifically remember, and it's also on my email, because after you phoned me last night, I went and found that email where I explained what I received from you and what I returned to you.
And
Mama?
Section 28,
Mm-hmm.
13,
Mm.
you would have brought an application, would you not?
You asked me to email it to you. Remember, I was in court with Speaker Matter, and then you asked me to email it to you that evening so that you can sign it the next morning.
Yeah, but what I'm saying is, so I signed the authorization.
Yeah, the 2813 authorization.
Yes, but did you put an application together for the authorization? How did what I'm trying to get at is, remember, for us to authorize Drew, usually we just put a thingy with a short summary of facts.
Yeah, but you told me not to do the mandate memo. It was just the... I'm just opening my laptop for you now. 1 second. What date was it, Mama? The 5th or the 6th?
I signed on the 6th. It should be 5th.
Okay, just checking now. Why can't I find that email? No, I think I didn't do that. I think the facts and all of that was covered in the email I sent.
27.
Yeah, in the 27, and then remember I did a summary of the 27 and the dockets that we collected, and that is when I said to you I need to consult with Fadil because.
Wait, remember, wait. Remember, Drew, the authorization is the 6th of December. Y'all got the dockets on the 9th of December. So you wouldn't have had the dockets.
No, I didn't have the dockets. We only received the dockets because on the 6th you sent the letter to Sentumule.
Yes,
Yeah.
That is what I'm saying. So what would you have based, and that's what I'm trying to get to. You based your facts on the section 27.
Correct.
Did you check to anyone before that, or did you base your facts on anything else for us to have those other names?
It was on the page that you gave me. That's why those names are there. It was.
And how do we arrive at some of those other offenses like forgery and uttering and...
Forgery and uttering, we generally put in our 28.
That's how
Yeah.
that's how
No,
I
it's
explained it, but he said, I have abused my power by doing that.
No, it's a standard thing because out of fraud we get forgery and uttering.
And that's what I said. When you look at that one paragraph where he says the alleged manipulation of procurement processes, that with the PFMA and fraud, almost invariably, there is forgery and uttering.
Yeah.
And that if we don't put it in, then we can't deal with it.
And remember with the
So what they're doing is, do they dissect word for word?
Yeah, that's why I stopped watching.
Yeah. Today I must have been the dumbest lawyer South Africa has seen.
Are you done for the day?
Yeah, I'm actually feeling sick. I got sick last week, remember?
Yeah.
And I had a panic attack. So for the first time, I'm taking meds for it. And after a while, I just felt I was zoned. And I realized I wasn't even paying attention.
No, but to answer your question, the names that I obtained or placed in the 2813 was the page with your handwriting and the names of the suspects. And then when I asked about it, you said that you, Dylan consulted with Fadil, and that's how the names came up.
I must talk to Dylan. If we have to have a quick WhatsApp call later, is it okay with you?
No, that's fine. I'm free.
Yeah, because, otherwise I'm very confused because they need to know from me tomorrow. Where did I get these names? And I need to understand where did I get those names. Now, it's fine if you say you got it from me, but I don't know where I got it from.
What you told me is that Dylan obtained it after consultation with Fadil. That is my understanding of it.
Okay. All right. I have to speak to him. I have to speak to him because he must have notes somewhere.
If you look at my emails, ask him to check the
My
emails.
laptop was stolen, so my laptop was stolen in January last year, so I've lost lots of my stuff.
But ask Dylan to check because he has his emails on his phone. There's an email between him, you, and I about the names as well as about the documents, the ones that were slotted in under Fadil's door. So there was a trailing email between us. He should remember.
Okay. I'll talk to him, and then if you don't mind, we'll chat a bit later on. Or else, I go there. I've already now abused my power by not asking where these names came from. I said to them, you know what, maybe I had a discussion with you. I just can't remember right now.
No.
And which would then be true. Drew, we had a discussion.
Yeah.
If you say that there was this paper. But where did this paper come from? Where would those names have come from?
That was what our conversation was. It came from consultation with Dylan and Fadil, and then you had written it down. Yeah.
Okay.
Okay.
All right. I'm going to talk to him, then you and I will check it. But thank you. I'm sorry, but they asked me for the name of every person who's dealt with the matter.
No, it's fine. I don't even know what's happening. I'll be very honest with you. I stopped watching because we are so busy with preparation for blue lights that I just don't have the time to listen.
And don't watch because it will really, If they call you, you leave the country.
Okay. Oh God. Okay.
It's not what you. It's not what you know.
Okay. No.
Today, I didn't know Section 28. I didn't know Section 27. I know nothing. I'm as dumb as two bricks.
I'm sorry.
Yeah. But it's okay because, you know what? Whether we like it or not, they're going to make our names shit anyway because you can just see. You know, especially when, remember he's a judge. You know, for him to make a comment, oh, well, this is basic law 101. I'm surprised you don't know it with your 30 years experience.
Oh, I don't even know what to say to that.
Exactly. And he's doing it, and he makes faces, they laugh with each other while you're still answering. It's so unprofessional.
Yeah, no, I don't want to go there.
Yeah. Well, we'll see what we're all going to do, but it's just going to be a shit show. But I'm going to talk to Dylan quickly.
Okay, but ask him to check my emails from, it must have been around the 11th, 12th or 13th of December because I went on leave on the 14th of December. So it would have been the 11th, the 12th or the 13th of December.
But he would have had to speak to Fadil after Fadil gave us the 27th, remember?
Yeah. No,
Yeah.
his indication is that he had spoken to him in December, so it was late November.
Yeah, late November.
Yeah.
Yeah, because Fadil's 27 is dated 21 November. So he would have had to speak to him between 21 November and the 5th of December because on the 6th we signed the authorization with these extra names.
Yeah.
Yeah. Okay. All right, I'm going to talk to him.
Okay, Mama.
All right, thanks,
Yeah, no
Drew.
problem.
Okay.
Bye.
All right, bye.
Thank you, Chair, Commissioners. Ms. Ramsamy, you refer to Advocate Johnson as Mama. Why is that? You can switch on your mic.
When I started with ID, before it became IDAC, Advocate Johnson was the head of office. And we had a choice between calling her ID or Mama J. And I respectfully call her that because she's not a bad person. She's not. You know, when I got sick, she was there. She was she's kind. It's just the work ethic that I have a problem with. And so I respectfully call her Mama.
Okay. So
I just cut the J part out.
Okay, this was the recording on the 22nd of July where you telling her how those names came about.
Correct.
And you are referencing emails that were sent in December 2024 where Mr. Perumal indicated that he had consulted with Mr. Adams.
Correct.
And those emails you have provided to us, we'll get to that. But if I understand it, the emails you are referring to in that recording are emails that were sent after, in response to your docket report.
Correct.
Okay, which comes after the dockets were collected and after the 2813 is authorized.
Correct.
Okay. So we should then go back into your statement to deal with the 2813 investigation, which is on page 21 at paragraph 49.
Mr. Rapesu?
Oh, page 21, paragraph 49.
49.
2813 investigation.
Returning to the events of December 2024, on the 6th of December 2024, before the staff meeting, I went to Mr. Rapesu, who had been designated as one of the investigators in the Adams referral. I trusted Mr. Rapesu. I had to show him the affidavit because I had such unease about what I was instructed to do, especially given the lack of substantiation of the allegations contained in this Section 27 referral affidavit, and the fact that I had been given names of suspects to include in the Section 2813 application, that I simply couldn't reconcile with the contents of the Section 27 referral affidavit. Paragraph 50. Mr. Rapesu briefly perused the affidavit before I had to return it to Advocate Johnson shortly before the staff meeting. I went to Advocate Johnson's office and returned the Section 27 referral affidavit, and she gave me the signed 2813 authorization. There was a meeting scheduled for 11 a.m. with the team assigned to the Adams referral, which took place in Advocate Johnson's office. Present in the meeting was Advocate Johnson, Mr. Perumal, Mr. Rapesu. Mr. Padiachi and Vessels were not present, and I. Mr. Padiachi and Mr. Vessels were not present in this meeting. Before I deal with the events that transpired from the 6th of December, 2024, I want to make it clear that Advocate Johnson and Mr. Perumal launched an orchestrated attack on General Masiamula and General Kumalo using IDAC's powerful investigation tools. And this will become evident in my statement and testimony.
Sorry, as I understand this, correct me if I'm wrong, the attacks were made at the meeting or not?
I make the statement.
Or do you mean they were made as the investigation was going on?
I think when my second statement is before
Yes,
Chair,
yes.
for the 22nd of January, Chair will understand the clear picture, including the notes.
Okay, okay.
But I don't make a statement of this nature lightly.
All right, no, thank you, thank you.
Can I also just seek clarification? So when you say an orchestrated attack from the 6th of December, you are referring to the investigations themselves being an orchestrated attack?
Correct.
Okay, and when you say using IDAC's powerful tools, it is the tools that one finds in Section 28, for example, the investigation itself?
28, 6, and 7 specifically, which has no judicial oversight, but is signed. And if I may give an example, yesterday, Chair was very concerned about a 28 that was sent with regards to Fadil Adams' arrest and who made the arrest. Had that been a Section 205 of the Criminal Procedure Act, an affidavit explaining the request would have been accompanied, and a magistrate would have interrogated the reasons.
Okay. Go to page 22, paragraph 51.
Paragraph 51. Everything about the process was concerning. 51.1. The speed with which everything had to be done without any evidentiary basis, and in certain instances, against my strict instructions to the investigators. The makeup of the team, while Mr. Manilal was designated as the Deputy Director of Public Prosecution, he had no involvement in the matter. I was the only prosecutor who had to report directly to Advocate Johnson. Mr. Sissoko, who for all intents and purposes is the Chief Operating Officer of IDAC, was not aware of the matter. The lack of evidence on the Mukwele matter, I distinguish this matter from the Lushaba matter, where there was a prima facie case. But in my view, I questioned whether it was within IDAC's mandate to investigate the Lushaba matter. The timing of certain decisions and actions. Paragraph 52. Returning to the meeting, it was a short meeting. Advocate Johnson informed us that she will be supervising the matter personally, like she had done in the July 2023 referral. As will become evident, Advocate Johnson was not merely supervising. She was dictating key decisions throughout the investigation. Before we left Advocate Johnson's office, she said that the dockets had to be collected that day and instructed me to draft a written request immediately for her signature. And she repeated that the dockets must be collected today. I did not understand the urgency, especially as it was Friday and nothing would happen until Monday anyway. She told me to address the letter to Major General. There is an error here. I was told to address the letter to Major General Khumalo. I didn't know the first name at the time, as I had previously explained. Mr. Perumal instructed Mr. Rapesu to collect the dockets immediately. He should not wait for the letter because he, Mr. Perumal, wanted to take the dockets home with him to Eastern Cape. Mr. Perumal also mentioned that Mr. Padiachi had already been briefed on the matter. I found this very strange because we were being briefed for the first time on the Section 2813 authorization, and it had only been signed earlier that morning. Clearly, Mr. Padiachi was briefed on an investigation that he knew would be authorized before it was authorized. Allow me to digress again before I continue the timeline.
The next,
Sorry, can you please reread the sentence starting, I found this strange?
Yes, Chair. I found this strange because we were being briefed for the first time and the Section 2813 authorization had just been signed earlier that morning.
Thank you.
okay. Then the next subtopic is, did Mr. Padiachi see, there's a missing E there, the Section 27 referral affidavit? This is the question that Chair, or the issue that Chair had raised earlier about Mr. Padiachi.
I think it was Commissioner Khumalo who asked. And
No, it was Chair. Okay.
Paragraph 53. I heard the evidence of Mr. Padiachi that he had not seen the Section 27 referral affidavit. I confirm that Mr. Padiachi had not seen the Section 27 referral affidavit in my presence. However, I believe that Mr. Padiachi either saw a draft of the Section 27 affidavit or the signed version. I say this because when Mr. Perumal and Rapesu and I went to Cape Town on the 6th of January, 2025, and whilst at the airport, Mr. Rapesu went to collect the rental vehicle. Mr. Perumal complained to me that when him and Mr. Padiachi were in Cape Town in November 2024, there was a shortage of hotels and they were forced to stay at the Formula One hotel. He expressed how embarrassing it was for him and Mr. Padiachi to meet with a member of parliament at the Formula One. For this reason, I doubt Mr. Padiachi's version that he did not see the Section 27 referral affidavit. Having said that, there was a lot of secrecy around this Section 27 referral affidavit. Had it not been for Mr. Perumal's comments at the airport, I would have believed Mr. Padiachi that he had not seen the Section 27 referral affidavit. As far as I was aware, before Mr. Perumal's comments at the airport, the only people who had seen the Section 27 affidavit was Advocate Johnson, Mr. Perumal, and Rapesu, because I had shown it to him and me.
Is your point that because he was with Mr. Perumal when they were consulting with Mr. Adams in November 2024, he would have seen a draft of that affidavit, or on their way back, he would have seen the signed version?
It could not be possible to sit in a consultation to draft an affidavit and not know the contents thereof or see it.
But he could have waited outside while they were doing that.
I will get to the relationship and the closeness later on, if it will be allowed.
So here you are talking about the original affidavit, not the one that has Pretoria and Cape Town issues.
Correct.
Oh, all right, thank you.
But it would seem that when you say it would not be possible that Mr. Padiachi, Colonel Padiachi was with Perumal in Cape Town, a statement was taken that he wouldn't have seen that affidavit. So it must be that you're also referring to the November,
The November statement.
yeah, the one that was shown here in the commission. Okay.
The one that I referred to here, it could be correct that he didn't see the one that was flighted, because I have heard that that is not the correct one. But my statement here is that the one that I am speaking about, the one that contains the PKTT and the vehicles and the lodges, it would have been improbable that he would have not had seen the original.
Let's understand. Are you therefore saying that this trip, the two of them in Cape Town, that would have been when they took the affidavit that you saw, the original one,
Correct.
not the one that was flighted?
Correct.
Okay, I understand.
Maybe,
Oh,
sorry, where you need to clarify for Commissioner Baloy. Even the affidavit that you saw, the original one, it was also dated 21 November 2024.
I cannot confirm that. I have a recollection of a different date. I also have a recollection of a conversation between Perumal and myself when this whole debacle of the where is the 27 referral as per my email was happening, where Perumal says to me, no, the ID must check, referring to Advocate Johnson, because I have WhatsApps from the 13th of November where Fadil is asking for things. So,
So it was November, but you're not sure whether
No, I
it was
cannot
the
confirm the dates.
21st or the 13th.
I cannot confirm the date. I just know that if, may I just point to the 22nd, Advocate Lee? January.
Before you get to that, the one that you saw would have been dated November 2024 as well, because in your application 2813, you referred to the section 27 in November 2024.
Correct.
Okay. But you can't recall who the commissioner was, you can't recall the date, because it wasn't something that you were focused on necessarily at that stage.
No, I think my focus was more on the content of that statement.
Yeah.
And your assumption that the affidavit was taken in November when the two of them were there together is based on the fact that they were there in November and it is a November affidavit. Is that why you think it must have been taken?
That is my thinking, my line of thinking with regards to that. Also, there are later emails that the commission will have sight of where Advocate Johnson, I'm now questioning the veracity of the affidavit itself and the lack thereof in the dockets that were opened. It is at that point that Advocate Johnson even sends me an email saying, ask Chief, he consulted, he should have those things.
Thank you.
Thank you. So if we can then go to the dockets, the topic, the dockets, on page 24, paragraph 55.
Thank you. Paragraph 55. After the meeting, I prepared the letter to Major General Khumalo. I point out again that the letter asks for the Valeria and Orlando dockets mentioned in the 27 referral affidavit, not Cape Town dockets listed in the flighted section 27 affidavit. There was a lot of commotion on that day. I do not refer to outside the office commotion. I'm talking about within the office. Bless you. Mr. Rapesu will elaborate on the docket retrieval issue. Ultimately, on the 9th of December, 2024, I had to change the letter request from Major General Khumalo to Lieutenant General Jacobs. I sent Advocate Johnson a WhatsApp message to tell her that based on the information I received from Mr. Rapesu, the letter had to be changed to Lieutenant General Jacobs. Her response was that I must shed the letter because it was not going to Lieutenant General Jacobs. She said she had written to Divisional Commissioner, Detective Services, Lieutenant General Sentamule. I was still unclear on the process to collect the dockets. Advocate Johnson told me to ask Mr. Rapesu to call Colonel Phillips and ask if Lieutenant General Sentamule had asked Colonel Phillips to hand the dockets over. The WhatsApp exchanges have been provided.
Yes, we can go to file 10, page 113. That's where the WhatsApp exchanges between you and Advocate Johnson that morning.
Correct.
occurs. You can take us through it. So the black would be yours, and then the white would be Advocate Johnson.
Morning, Advocate Johnson. This is the 9th of December 2024, 8:38 a.m. Morning, Advocate Johnson. I trust you are well. The letter that was sealed for Kumalo has to be changed to Lieutenant General Jacobs. I have the sealed bag. May I leave the details in bag with Ino and await new signed letter? Once received, Mansa has made arrangements to collect the dockets. Not going, this is now Advocate Johnson, not going to Jacobs. Shed the letter. I wrote to DivCom on Friday. She will revert today. I know, I state at 8:40, noted, thank you. 11:40, I send another message. Advocate Johnson, my apologies for disturbing you. Please advise what the instructions are about collecting the dockets. Are the investigators to wait upon the reply and you giving them the go-ahead to collect the dockets? Thank you. 114.
You can just go to her reply because that's a repeat of your question, of your message.
Thank you.
So this
She replies at 11:40, they must wait till I get the go-ahead. 11:42, I will advise the team. Thank you. I then send another message at 11:44. Mansa received a call to come collect the dockets in 30 minutes in CBD being Pretoria. Please advise if he should. From a Colonel Phillips. Advocate Johnson replies at 12:00. Ask him to call Colonel Phillips quickly and ask if General Sentamule asked him to give us the dockets. Once you revert, I will tell you what to do. They confirm that
Just go to the next page and read it. It's the full message on 115. They confirm.
Thank you. They confirm that it came from General S. They are asking us to also give them a copy of the letter sent for their record purposes, but they will provide the dockets today and we must drop off the letter at our convenience. Advocate Johnson replies, get a copy of the letter to General Sentamule from Ino and take it with. The dockets must be copied immediately and then the originals handed to Ino. Thank you. We'll attend to it now. At 14:53, I send another message. Good afternoon, Advocate Johnson. I have received dockets. I have made a copy and handed originals in an envelope to Ino. I will peruse all the sections and provide a report to yourself. She replies, thank you. The next morning.
Okay, we'll get to that later. So then we have to return to your statement at page 24, paragraph 56.
I later confirmed with Advocate Johnson that the dockets were received from Lieutenant General Sentamule and that Rapesu had been requested to provide written request for their record purposes, but that the dockets would be made available that day. Advocate Johnson then asked me to get a copy of the written request to Lieutenant General Sentamule from her assistant, and that it must be delivered when the dockets are collected. She also gave me an instruction that the dockets must be copied immediately and the originals must be handed to her personal assistant. A few hours later, I advised Advocate Johnson that I had received the dockets, a copy was made, and the original placed in an envelope given to her personal assistant. I told her that I would peruse all the sections and prepare a report to her. The request for the dockets was yet another matter that did not sit well with me. We usually request certified copies of the docket, and the originals are retained by whomever the request is addressed to. In this instance, I was asked to request for the original dockets, which is evident from the letter to Major General Khumalo. Before I deal with my report, I must address the issue of the letter to Major General Khumalo. Advocate Johnson testified that we sent the letter requesting the dockets to Major General Khumalo, and that he had indicated that the dockets were not with him or were not his. As stated above, the letter was never sent to Major General Khumalo, and Advocate Johnson knew that because she told me to shed the letter. Advocate Johnson told me that the letter had been changed and addressed to General Sentinel.
Sorry, I may have misunderstood. Was the one that you had to shred not the one that was to go to Lieutenant General Jacobs?
No, Chair.
Yes.
The instruction on the 6th was to draft to Lieutenant General Mbuso Khumalo. That letter was in the envelope that was sealed, marked by hand. That letter was never sent. So when I got to the office on the 9th, that letter was handed in a sealed, almost like an exhibit bag letter, a document thing, and handed to me by Innocent, because obviously Rapeso had to go and fetch the dockets. Rapeso, he had not come to the office with regards to collecting the letter or anything, but he will explain what his actions were. He called me and stated they want the letter changed from Khumalo to Jacobs. I then contacted Advocate Johnson. Remember, I'm not the signatory of the letter. So I'm informing her that the person it is addressed to needs to be changed to Jacobs. She says not to worry, shed the letter, because they've already contacted Sentimule.
Oh.
I apologize for not using the titles, the lieutenant.
Okay, all right. It was a reference to Jacobs at a time when you were talking about a letter that was to have gone to him, that you then talked about the shredding, and I thought, yeah, the shredding related to Lieutenant General Jacobs. No, thank you.
Sorry,
that
sorry,
clarifies
Chief.
it. That clarifies
I'll
it.
read slower but louder.
That is at page 113, where you say, Morning Advocate Johnson Trustwell, the letter that was sealed for Khumalo has to be changed to Lieutenant General Jacobs. So at that stage, it's still to General Khumalo. It's not, you are telling her it has to be changed.
Correct.
And she then says, shred, it's not going to Jacobs, shred the letter, which the only letter then is to General Khumalo at that stage in the sealed bag.
Correct.
Okay.
Is there particular reason why you, as the process you describe about getting dockets, that you make copies, you get certified copies and leave the original with its owners, the agency that owns the docket? Is there a particular reason for that?
If I may just put it in a simple example. Centurion Police Station is the owner of that docket. Valeria Police Station is the owner of that docket. The tracking of those dockets are done on the CASing system. If Valeria is asking for Centurion docket, it must be transferred to Valeria. On the face of the brown copy of the docket, it would be scratched off Centurion put Valeria, Valeria will have to recast it so that it can be checked for safety reasons. We all know dockets go missing, get bought, destroyed. So that is the reason we don't have a casing system at IDAC. So it would, also with the other 27 referral that I discussed earlier that I attended to in 2023, we did not, there was a reference to another docket. We did not call for the physical docket in its original state. We called for a copy. And that copy comes with the front certified. Because for me, it was a situation of what are we going to do with these? Like, are we now taking these dockets? Are they going to be cast on one of our investigators? And if the system shows it's still not cast on one of our investigators.
Say it's not.
It's, as far as
They're not.
my involvement is in it would only be Lushaba that was now recently, on the 12th of June.
Yes.
But I'll deal with that aspect of, and I speak about the movement and the changing of the CASs because it comes up later as well with the Lushaba matter.
Thank you.
Thank you, Commissioners. I'm going to move on to a next topic, Chair, but I see it's 3 minutes to 1. If maybe it would be a convenient time to take the adjournment now, because that deals with the docket report, which is going to be lengthy.
Let's adjourn and resume at 2 p.m.
All right, it's 13:59. We are ready to start. Please make sure that your devices are on silent. Thank you.
Yes, Ms. Seegers Ncube.
Thank you, Chair. Ms. Ramsamy, can you put on your, thank you. Just before the adjournment, we had dealt with paragraph 59 of your statement on page 25. We were moving on to your docket summary report. So we can start at paragraph 60 on page 25, but I just want to confirm from you that on the 9th of December, when you receive the dockets, whether the dockets that we have in the bundle file 10 are the dockets that you had received, and whether they were only the Valeria and Orlando, or whether you had received others as well. So if we can go to page 117 of file 10. And I think it goes all the way to page 160.
117.
Yes, 117. If you could just have a look at whether those were, I think they are because of how you describe the dockets in your docket summary report, but I just want you to confirm.
Correct.
Okay. So if we can then go to your statement at paragraph 60 on page 25, you can start there.
Paragraph 60. On the 9th of December 2024, we received the dockets. 61. I then proceeded to prepare a docket summary report. This is a report setting out my assessment of the evidence contained in the dockets and whether the evidence revealed a prima facie case of the allegations contained in the Section 27 referral affidavit. Paragraph 62. I sent the docket summary report to Advocate Johnson on the morning of the 10th of December 2024.
Before you proceed, can we just identify the document summary report? If you go to page 163 of file 10. Are you there?
Correct. It is the correct report. It starts at 163 and ends at 165.
Okay. And how we are to understand it is that you would deal with the dockets that were referenced in the Section 27 referral affidavit.
Correct.
And did you receive the Cape Town dockets as well?
Correct.
Okay. Now, what I propose we do is we go through your report and then we can go back into your statement. So if we can go to the report at 163, I will then indicate on the docket which docket we're dealing with when you go through your report. So the first one is 403. You can go through that, and then that docket should be at page 146 to 154 of the bundle, if you can just confirm that.
Correct.
Okay, so let's go to the report at 163, and you can just read first from number 1. You don't have to read the case number, but we know it's 403.
I marked the report confidential. It is titled Docket Reports. Number 1 is 403, Alleged Offences, Corruption, and Defeating the Ends of Justice. Docket content, A clip, 1 statement. A1, F. Adams. Allegations that a polygraph test was failed in July 2024 by Major General Madondo, who had 2 cases of tax evasion and that the head of vetting, Brigadier Ncube, was tasked to ensure that no investigation ensued. This statement is vague, does not indicate where the allegations emerged from, nor what evidence is at hand to substantiate them. B Club has an information note to the Provincial Commissioner, Lieutenant General Ntombeni.
Before you proceed, can I just ask you, what is a B clip?
A docket is made up of when it opens up, there's three parts to it. So the A clip is where the statements are filed. The B clip is generally correspondence between the prosecutor, the attorney, maybe LCRC, or it also has, you'd find stapled in there the receipts if exhibits are handed in or taken for testing, then you'll have a lab receipt. So that is where we note, or as prosecutors and police officers, we would see where what is transpiring or whether this has been done, what communication has been filed. The C clip is a diary. It is supposed to be communication between the commander, the investigating officer, or the person allocated to the docket, and then later on it becomes communication between the prosecutor and the investigating officer, or the commander of the investigating officer. But that is A clip, B clip, and C clip.
Okay. And then, so you were going to say something when I asked you about the B clip, when you were reading about the information note?
Okay. With regards to the information note, I do not summarize it here, but in essence, because the dockets had already been in Advocate Johnson's office and we had discussed it as also later on with regards to the information note, I just want to place on record that the information notes of addressed to Provincial Commissioner state the same thing that I'm saying. There's nothing in the docket. There's an A1 and unsubstantiated allegations.
The words in italics, is that you expressing your view about the contents of the docket?
If I must be honest, Commissioner Kumalo, it's me expressing my irritation.
Why were you irritated?
We have a 27, we have a 2813. We now have dockets. I have never in my life, and I've been in NPA, and prior to that I was with legal aid, I have seen statements. To me, it looked like someone just went there and scribbled. It just, threw things in, which is then explained in the body of my email to Advocate Johnson when I send the report.
And just to be clear, the statement you are referring to is the statement of the complainant in the docket?
Correct.
That would be the A1. And the information note is the document at page 151, if you can go to 151 of file 10.
Yes, correct. This is the information note.
And so that was in the docket when you got it on the 9th?
It was in every docket that I received, yes.
Okay.
This information note is not an IDEC document.
No, Commissioner, it's not. It is it's my understanding of this is that when these allegations were made against high-ranking officials within SAPS, the instruction was that the Provincial Commissioner is to get weekly or monthly updates. Mr. Rapesu will speak to that because he was the one that collected the dockets and he was told with regards to that.
Okay. So then we can go back to your report.
C-clip, one entry upon opening the docket. So the entry in the C-clip is what is generally termed the opening entry on a C-clip. Generally, it would be the date, time, of the opening and the A1 being obtained, the contact details of the A1, just so that if it's not on the A1. Also, if there's potential witnesses that the A1 or the person, the complainant, has, it would be noted there. And a brief summary of the A1 allegations.
Okay, the next one, which is 404, Valeria, and it's on page 163, and the docket is at page 136 to 145, if you could just confirm.
Correct?
And those information notes were identical in each docket because it dealt with all the cases
Correct.
in one information note.
Yes.
Okay, so you can then go to your report at 163.
404, alleged offenses, corruption and defeating the ends of justice. A clip, one statement. A1, F. Adams, alleges that he has sensitive information relating to the abuse of funds from the Secret Service account that contravenes PFMA. Further, that the docket CAS 38 of, I won't repeat, or will continue with that, in which General Lushaba was the complainant, in which Lieutenant General Kumalo, the divisional head of crime intelligence, facilitated the act of defeating. Further, allegations of nepotism, placing persons and family members in strategic key positions that affect service delivery. I make the same statement in italics. This statement is vague, does not indicate where the allegations emerge from, nor what evidence is at hand to substantiate them. B clip, it had the information note to the provincial commissioner, and the C clip again, one entry.
And then the third one, which is 405, that docket is at page 117 to 125. If you can just confirm.
Confirm.
Okay, and then you can deal with your report at 164.
Thank you. Alleged offenses, corruption. A clip, A1, alleges major abuse of power of the Secret Service account by Lieutenant General Kumalo, Divisional Com of CI, together with Major General Lushaba, the CFO of CI, funds being channeled into the KZN political task team, which is a front for the former minister, Mr. Trele, purchases of vehicles through this fund allegedly bought for the task team but used for the former minister's activities. I state in italics again, this statement is vague, does not indicate where the allegations emerge from, nor what evidence is at hand to substantiate same. B clip has an information note to provincial commissioner, and the C clip, one entry upon opening of docket.
Now then, you deal at number 4 with the Cape Town dockets, and you say respectively are the first dockets opened and have the same information as above. Where did you get that information from? From the bundle? Okay, and then Valeria 38 has been perused and will be relevant for evidence purposes. You don't summarize the A1 or deal with that. Do you see that?
38 was not one of the dockets that was referred by Adams. The 38 was what we would term an exhibit, in the sense that the claim was that that docket was not properly investigated.
Okay, which docket wasn't properly investigated? That one itself?
That 38. And that
Okay.
one was opened already in 2024.
22,
22, sorry, 22.
yes.
Yes, my mother's not going to be happy with my dyslexia after this.
Yeah, okay. Now, you say the investigation into this matter is poor and disturbing the offense of theft.
Yes, as I had done with all the other dockets, I had thoroughly perused A clip, B clip, and C clip. I found discrepancies, but I'm not an investigating officer. My discrepancies were based as a prosecutor on I also realized that very little effort had gone into that docket. And had it come to me for a decision, I probably would have put a very nasty diary entry to the commander as to why it was done so, for lack of a better word, sloppy.
I may have missed it. Did you, I see it's on 161, but did we place it on record, the date of this summary?
We are getting back to it as to when it was sent, and because there's a WhatsApp before that precedes the sending of the document. Thank you. So that, and then if we can just finish off with the report, you then have 6 instructions to investigators. So this is going to, is it primarily addressed to the investigators, or is it primarily addressed to Advocate Johnson and the investigators are copied in? How do you?
Advocate Johnson had not asked for this report. No one had asked me for this report. I, upon receiving the dockets, felt compelled to do this report because of my gut instinct and whatever happened on the 6th, and then when I received the dockets itself, it needed to be reported in a manner that we as prosecutors would report dockets. When you give an evidence report, it's generally to a senior to make a decision because you're not finding what you're supposed to, or they think you're supposed to be finding, or what the SAPS thinks you're supposed to be finding, or the complainant thinks you're supposed to be finding. So, but my instructions to the investigators were based on my unease and the lack of substantiation in the docket itself.
Okay, can you just take us through your instructions to the investigators?
Instructions to investigators. F. Adams is to be consulted. Full and detailed draft affidavits to be obtained before prosecution plan can be discussed. One of the 2 prosecutors must be present when this consultation takes place. You will also note that I'm trying to now involve the DD that is allocated on paper, because I'm working on my own under the I'm going to do the supervision of Advocate Johnson. So by saying that, I'm saying one of us, either the DD or myself, need to be present when this consultation takes place.
Okay, continue.
All information, documentation, and witness names, etc., to be contained in the affidavit draft from F. Adams.
So you want the evidence?
Correct. He's saying that he has proof. He's saying that someone slotted things under his door. He's opening dockets, but he only makes vague allegations and then pops up a name here and there, and then you don't know what's happening exactly. So I wanted a full and detailed draft report or affidavit from him. And he must advise us, okay, this is a witness that I know will come forward, or this is a possible witness, and this is the evidence that I have.
Can I just ask you before you continue, why didn't you at this stage say to Advocate Johnson that section 2813 that you had asked me to apply for, to do the application for on the 5th, I've now looked at the docket. I was uneasy before then, I'm even more so now, because in fact, the evidence that he says is contained in these dockets, it's not there. I don't see anything. So I don't think we should continue with the 2813.
That was one of the reasons I did the report. And the WhatsApps will show that I request that I send it to her before I send it to the rest of the team. My intention was to discuss it with her and to discuss my concerns on that day. However, the preceding messages that will be shown to the commission will then illustrate why that conversation never took place. It did, however, take place later on.
Which is that? Which does that?
Sorry?
You say it did take place later?
The conversation between myself and Advocate Johnson did take place in January about my concerns.
Okay. And then just before okay, I think you should finalize or finish off with the instructions, and then we'll go back to what you say in this report and then what was in the 2813.
Prosecutors to be informed before any interview consultation to take place with any person relating to this matter. May I explain why I put this in? There was so much speed and so much of need to get going where the prosecutor is not even ready to say, let's set down a plan of action. How are we going to ring fence? What? And Mr. Perumal was on this whole mission of, we need to do this, we need to do that, we need to contact this person, we need 28s for this, we need 28s for that, we need the files for the vetting. But I'm saying there's no substance. I don't have anything to even draft a prosecution plan. So my instruction is very clear. Nothing is to be done without my knowledge.
Would a prosecution plan proceed ordinarily? Would a prosecution plan precede the kind of activity that you say Mr. Perumal was involved with, demanding or requiring this and that, statements being taken, that would be led by the prosecution plan?
Correct.
Okay, and number 4?
Number 4 is no section 28 is to be issued or served without the prosecutor perusing same and then submitting to the head of office for signature.
What do you mean by section 28?
Section 28, 6 or 7, for information or for persons to be consulted with or interviewed, or summons to be interviewed, or for any documentation books or anything listed in section 28, 6 and 7 to be done.
And why did you put that in?
Because of the way Mr. Perumal was insisting this. It was brief conversations that he would phone me and say, hey, we need to do this, or hey, we need to start moving with this matter. I was also going on leave. So, and I'm going to repeat it, and I know it's going to sound like I'm repeating it ad nauseum, but my gut was not feeling comfortable compared to the 27 I had done in 2023 versus this.
And at that stage, there's no evidence, so...
There's nothing, there's no evidence. What do you 28 if there's no evidence? What evidence are you? Are you going on a fishing expedition?
Okay, and then you say, please note that there are 5 CAS numbers allocated. Once draft is obtained, the team can discuss the way forward. This is the draft affidavit. Now, can I just understand why you were asking for a draft affidavit? Because you have the section 27. What is the status of the section 27 as in the investigation? In the 2813 investigation, what do you call the section 27 referral affidavit?
My understanding is that the 27 is supposed to be your A1.
It's supposed to be your A1?
A1.
Okay.
It's a complaint received. But that's my understanding. It's not implemented within IDAC. My understanding is if you are filing an affidavit with allegations, that is your A1. That is your complainant statement.
Can it be supplemented?
Yes, it should be supplemented if needs be. But it cannot be a standalone affidavit and from there, investigations flow in a different direction. Or not different direction, but investigations flow where we're taking now new A1s. But I was told that this was told to me in 2023. I was shut down with this. When I was dealing with that specific 27 in 2023, I held the same view, that the referral affidavit needs to be the A1 in the dockets. I was told that's incorrect and it's not going to happen that way.
So once the investigation has been authorized under 2813, was the process then that you have to then obtain a new affidavit?
No, with the 2023, I'm just going to refer to it as the 2023 referral. That complainant had come with a letter and a statement, an uncommissioned statement. When the matter progressed before myself and the other prosecutor got involved, the legal representative of that referrer submitted a very extensive formal affidavit, and that is in the docket. So we received two different, how do I explain it? So it would have been like this. We had the first where it was just a statement that she signed, and then we had the affidavit referral in 2023.
Okay, but that I suppose is different because in this instance with Mr. Adams, you have an affidavit. The section requires that it be either affidavit or it be a declaration. So in this instance, you do have the affidavit from him, but in your docket report, you're saying we must get a draft affidavit from him.
But a draft supplementary.
Oh, okay, so what you're intending is that it must be a separate. Okay.
Because also, you must also remember now, I'm in possession of original dockets, where A1's already existing. So you can never have an A1 and then take another A1 and then take a supplementary. It's an A1 and a supplementary, or an A2 and a supplementary.
Okay, and the purpose of this affidavit that you were saying now needs to, because you say if Adams to be consulted, full and detailed draft affidavit to be obtained, you put a draft in bold, and what is the purpose of that? So you're not wanting a complete document from him. You as the prosecutorial team with the investigators want to sit with him and take a statement from him. And that is now part of the preparatory investigation,
Correct.
which is the 2813.
Correct.
Is that how the process works and is supposed to work?
Which process?
The process.
No, it's not supposed to be like that, but it's generally in IDAC space at the moment that people or prosecutors get draft affidavits. When most prosecutors prefer the draft only if the investigating officer is suggesting that this person is a 204. Then it would be a draft. But we generally, because we're prosecution-led, if the investigator says he needs to consult with you and he goes to you, I will constantly be updated about what is in the draft. They'll either send me WhatsApp pictures, they'll email me the draft, I'll read, I'll say, okay, but this witness is indicating that Mr. X has in his possession emails. Has it been canvassed? Or it would be, the deponent is saying, in 2024, I was in Limpopo and, whereas we have proof that he was in fact in Dubai. And I would then ask, has this been canvassed? Why is he saying this?
So You are, when this affidavit is being prepared for Mr. Adams, you're trying to gather evidence.
Correct.
To see whether there is a case, a prima facie case, but you also in that process preparing an affidavit for him as the prosecutors.
It's supposed to be that way, yes,
Okay.
because of the prosecution-led guidelines.
And assume that if you meet with him and he gives you all the documents and you're now convinced that, well, there is a case here, you then assist him in preparing that statement for him as the prosecutors.
I wouldn't assist, I would be present.
Okay.
The reason I'd be present is that I would be able to assist the investigating officers and the witness with regards to the structuring of the affidavit.
Which is what happens later on
Later
in
on.
January
The
with
prosecutor
supplementaries.
is not allowed to become a witness in their own matter.
Yes, that is what I was trying to understand. So when you give the instruction to the investigators, you're removing yourself as being a potentially a witness, but you're still consulting with the witness when that statement is being prepared or being taken.
Yeah.
It's just that it's the investigator that's doing the drafting and that. Okay.
Can I put it to you in a different way, in an easier way? Because of Section 28, prosecutors are allowed to consult with witnesses, right? My previous DD, who has retired, deputy director, he always said to me, because he comes from DSO, never consult with the witness where you don't have a statement, at least a draft, because you're walking in blind and you are going to be a witness. So if you're going to consult with the witness, ensure that you have a draft in front of you. You know what you're going to question and how you're going to assist the investigators. So that is what I was trying to say.
Okay. So as part of that process, you say that the Adams is consulted, and then one of the two prosecutors to be present when that consultation takes place. So you want the draft statement before you plan your before you prepare your prosecutorial plan.
If there's ever going to be a plan, because my thinking was when we go for these supplementaries, because now we've got dockets, and we instructed to investigate these dockets. When we go for the supplementaries, obviously he's now saying, and he's publicly said it, I've got documents, they were slotted under my door. Obviously in those documents, it might actually substantiate, and to an extent some of them did, I'm not going to lie. Some of the documents that I saw on the 19th of December did
Substantiate what was contained in the A1s of the
A1s,
dockets,
yes.
not the Section 27 affidavit that we've seen? Or
Some of,
what?
no, not the one that you've seen, no. But
Okay.
because, am I allowed to speak about the forklift?
The forklift.
Yes, no, yeah.
One of the issues that I picked up here of the one that was flighted is there's no mention of a forklift at all. But Mr. Rapeso will confirm that we received, we just had to trace it, Langlachte docket for a forklift, and it was in the 27 referral. And the supplementaries that we took was one of them for the forklift. And the first 3 witnesses that were identified were from the forklift documents.
Okay, your point being that if there wasn't mention of the forklift, why were you going down that rabbit hole of investigating the
And there
forklift?
it was multiple consultations.
Can I just ask relating to this? What is there a guideline or what informs what goes into this draft affidavit that you're getting? And it's related to what you've just spoken to now, which is you have a Section 27 affidavit.
Correct.
And then you get so the one that was flighted here, I want to use it as an example. And then you get the Mr. Rapesu supplementary affidavit that speaks about the PKTT, when the Section 27 that supposedly is the basis for the investigation says nothing about the PKTT. On the face of it, it looks like Mr. Rapesu would have sat down and suggested to the witness that you're not saying anything about the PKTT, let's talk about the PKTT, without it being found, I'm saying on the face of it, without it being founded on the Section 27. And I guess my question is, what is there that avoids suggesting things to witnesses or in a statement to avoid and to prevent, in fact, investigators imposing what they really would like to be in a statement which the witness may not have been interested in, but as seems to have happened in your cases that we are concerned about, that investigators had their own stories that they wanted to tell and that they wanted to be investigated, and they went to a witness and said, give me something that deals with this.
Generally, I would assume it's ethics and morals that would guide someone, not to do that. As we can see, it's not done that way. But generally, certain investigators and certain prosecutors don't work in isolation. I personally, since the 1st of March 2023, have never gone to a consultation without at least 2 investigating officers or another prosecutor and myself. It's the safety net. So in some groups they do, and some groups they don't, but with the team that I worked with, it was never a prosecutor or an investigator going on his own. But I will qualify that with the fact that you must also know that if you have 2 investigators that have the same agenda going to that witness, which is one of the complaints that I do make to Advocate Johnson, and it is in an email, where prosecutors and other investigators were being excluded, and things were being done in a certain way, and statements were taken in such a manner that it doesn't even give you an offense.
I guess what I'm asking is, and it's part of a debate that was had with Ms. Johnson, about what Section 2813 permits to be done, because you look at a referral, it doesn't speak to anything that you now find in an affidavit. And I think her answer about those kind of concerns, and I paraphrase how it would have been raised with her, her answer would have been along the lines that, well, when we investigate and the stuff comes up, it may not have been in the Section 27, which is silent about a particular topic. But when we now, as we do investigations under 2813, then we end up, finding this stuff, and that becomes justification for why, you have matter that looks like you went outside the parameters of your affidavit.
If I may give a practical example of, remember I did the 27 in July. So between 1st of March and April, I was given what we call alphabet soup. So we've attached acronyms because the companies or whatever, just to shorten it, that we were investigating. And I think it was towards the end of March, I had discovered that there's a link from a project that is already authorized to another docket that is within the DPCI space. It is also investigated by the DPCI that has been seconded to IDAC. But the link and the suspects are glaring. And I approached the project manager as to what do we do now, because some of the accused or identified suspects are on the 28 that's already authorized. Some are not, and the scope in which of the parameter, the legislation, that some of the legislation that's applicable to that offense is not covered in the initial 28. She said to me that we would have to do a new 28. So I said, no, but why? Why would we need to, why can't we do an addendum? Because an addendum is contractually binding, and it would make sense because we discovered it during the course of. And so there was a meeting that was set up with Advocate Johnson, and we asked her, should we do a new 28? So then I asked, but can't I do an addendum? And she said it was fine. The addendum was drafted, it was attached and filed to the original 28. And that is the process we followed with 3 other of my matters.
So that addendum would be a foundation and an explanation how you end up with these new other people that were not in the original. Thank you.
But in this instance, if the section 27 affidavit that you saw didn't have the allegations contained that you see in some of the A1s in the dockets, what do you do then if the decision is then made that, well, even though it's not in the section 27 affidavit, because it's in the dockets that have been referred, we should still investigate it? What would the process then be?
I would have still asked to do an addendum, but because in my 2813, and I'm standing by it, the original 27 had PKTT and slush fund and polygraph. That 2813 stood. However, my concerns were about what substantiated it. We know you've got resources. I've got interlocutories, I've got high court applications, I've got trial matters to be attended to, and I'm dealing with something that doesn't have substantiation.
And in your 2813, you don't mention the PKTT.
I was told specifically not to mention PKTT.
Was that in the, okay, so let's just step back. So you do the 2813 on the 6th. At that stage already, you didn't mention PKTT. Was that a specific instruction, or was it to keep the 2813 vague?
It was to keep the in the 2813, I was not allowed to mention detail. I was told, keep it vague.
Okay, so even though, okay, that makes more sense. I just wanted to confirm that it wasn't, as you said earlier, a specific instruction not to mention the PKTT. It was not the detail of the allegations in the 27. It's like how you would just say this is what there was.
If I may explain why I understood what keep it vague meant.
Can you do it with reference to the actual 2813? Maybe we should do that on page 107. Because you don't mention any names or specifics. So at 1.2, for example, you say the office received a complaint in terms of 27 in November. 1.3, allegations leveled against senior members of SAPS, allegations regarding the appointments of various high-profile officials, unlawful actions regarding the vetting and polygraph testing perpetuated by officials of crime intelligence. But in you saying the section 27 that you saw, names were mentioned.
Correct.
But not all the names that you were given by Advocate Johnson to be suspects.
if I can just explain
Yes.
the practical reason why maybe even Advocate Johnson said keep it vague and she knew I would understand. When we were dealing with the 27 in 2023, the names of the individuals in that investigation were so high-ranking and so high-ranking, let's keep it at that, that we kept our documents vague. Even our reports and all of that, until the investigation was completed, we would hand deliver progress reports. Information leaks.
Okay, so I can understand that because when we looked at the, which Commissioner Baloy mentioned, the consideration of mandate document, for example, doesn't really give you any detail. It's very scant. So I can understand that you would want to keep that vague, right? The 2813. But here we're talking about, so there's a mention about the PKTT. Where would one then find in your vague 2813, where do we slot PKTT in between 1.3 to 1.7?
Fraud and corruption pertaining to awarding of tenders and/or contracts within SAPs and/or circumventing of procurement processes. Because remember, it's the purchase of the properties, it's the forklift, and it's the use of the SSA fund for laundry and those things.
Okay. And the 20, this wasn't your, I mean, you've done a 2813 before in respect of the previous 27 referral, but have you only done two 2813s or you before
No,
this?
I've
or?
done multiple 2813s.
Okay.
Most of them are as vague as this.
Okay, and that's intentional, or is it always on a case-by-case basis that she gives that the instruction is given to keep it vague?
This time she said keep it vague, and I'm assuming that she understood, or she knew that I would understand because of the other matter. But our 2813s are not, we don't, we work, so we're different units, right? We've got the ESCOM, the Transnet, I work in security cluster unit. It's the Zondo recommendations for the security cluster.
Yes.
It is high-ranking crime intelligence, high-ranking SAPs, high-ranking political individuals that were alleged to have fleeted money from SAPs and SSA. So we generally keep it vague like this.
Okay. Then can we, are you covered? Okay.
Thank you.
We can go then to the email. I think it's first the WhatsApp message that you send to Advocate Johnson on page 161 of, we'll first deal with the WhatsApp, which is on 116 of file 10.
Are we going to flight the whole thing?
We are just going to deal with the good morning, Advocate Johnson. I have prepared the summary and preliminary instructions for the team. May I email them to you for your guidance before sending to the team? That's at 10:50 on the 10th.
Yeah.
And she says, yes, please.
Correct.
Which you then do, if we go to, still in that same file, we go to page 161, the bottom of 161 at 10:57.
Good day, Advocate. IDAC docket summary. Good day, Advocate Johnson, for your perusal and guidance.
Okay, and she does, Advocate Johnson then later responds to that, but can we just deal with, at that stage, I think there's an acknowledgement if we go to 167 of the document, file 10. At the middle of the page, page 166, my apologies.
From Advocate Johnson, Tuesday, 10 December 2024, 11:05, to Drishanta Ramsamy, Dylan Perumal. RE, IDAC docket summary. Drew, noted, thank you. Please run this by Chief. He had interviewed the complainant. It would help if he was able to peruse the document and then indicate if he thinks the complainant will have access to the details we require.
And that is in response to what is set out in your docket summary, because your email to Advocate Johnson just says for your perusal and guidance.
Correct.
So she's responding to what is contained in the docket summary.
Correct.
To say you must run this by the chief. So what is it that you're running by him? The requirement to get or the instruction to get the draft affidavit and the documentation, I'm assuming?
It would be the documentation, because I remember having a conversation.
I think we get to that later where
Yeah.
he responds, yes. But that's later in the day because there was a lot going on the
There was
10th.
a lot going on, but he indicated that, yes, they have seen the documents that is in Fadil or Mr. Adams' possession. And a lot of my concerns will be calmed.
Okay, then I think we have back to the WhatsApps
Correct.
from Advocate Johnson at page 116, file 10. So we know that she acknowledged your summary report, and then that was in the email at 11:05. You don't really have any discussions with her during that
afternoon.
day. She sent you WhatsApp at 16:03, which starts with the one just below, yes, please. You can read that and then take us from there.
Drew, speak to Chief. I need you guys to urgently subpoena Lushaba's bank accounts before they move money. From the date he was acting as DivCom to date.
Okay, let's just pause there. So at this stage, we know that you've sent the summary, and in that summary, docket summary report, you're saying that no Section 28s are to be issued without your perusal. Do you know whether Advocate Johnson and Mr. Perumal had any conversations during that day before she sends this WhatsApp to you?
It's evident from Drew speak to Chief, because when I called the Chief, he indicated that Advocate Johnson received information that there was 50 million rand or 50 million rand of SSA money, Secret Service account money, that was being moved out of Lushaba's account. I apologize for not using titles again.
Okay. But that is when you then call him after she sends this message. She's just telling you to speak to Chief. And at this stage, Chief hasn't yet, which is Mr. Perumal, he hasn't responded to your email where you've dealt with the docket summary, because you sent it to both of them. So you then, if we can go into your statement before we continue with what happens the rest of that day, paragraph 62 on page 26.
I sent the docket summary to Advocate Johnson on the morning of the 10th of December 2024. To summarize, I reported that there is no substantiation in the dockets for the allegations contained in the Section 27 referral affidavit. Had the correct process been followed, I would have considered the dockets at the time when I prepared the Section 2813 application for authorization. In fact, it would have been preferable to have had the dockets, since they were existing case dockets, at the time when the consideration for the mandate memo was prepared, which I was not involved in. 63. In the 6 December 2024 meeting, Mr. Perumal and Advocate Johnson indicated that the dockets are what was referred to IDAC in terms of Section 27 referral, and could only be collected after the authorization. This did not make sense and was yet another red flag that caused my unease.
Let me just understand what's being said there is that you, Mr. Adams is referring in his section 27 referral affidavit to dockets. And what Mr. Perumal is saying is that you can't have the dockets before the 2813 is authorized, then you have authority to go and get the dockets.
What they are saying in essence is that Fadil didn't only make a referral to us. Mr. Adams, I apologize, did not only make a referral, but he referred those existing dockets to IDAC. I did not understand it that way.
Okay, so it wasn't just the section 27, it was to investigate the dockets as well.
But
That's what he said.
It didn't read like that.
Okay. So then if we go to 64.
Since the Section 27 referral affidavit referred to the dockets, I thought that we would find in the what we would find in the dockets would be prima facie evidence of the allegations contained in the affidavit. It did not. In fact, it had no new details. Again, I need to digress before I continue with the chronology. The Commission will note from my docket summary report that the B clip to all the 3 dockets contained an information note from Major General Kumalo to Lieutenant General Mtumbeni, the Gauteng Provincial Commissioner, wherein an assessment similar to mine on the merits of the dockets were made. Advocate Johnson would have had the benefit of that information note and my docket summary report as early as 10 December 2024.
Okay, then we get to the premature summonses.
Before you do that, Advocate Johnson gave the impression in so many words that she doesn't get involved in the minutiae of reading documents. Depends on, it works on briefings by investigators, I think largely, but by yourselves, that team. And so some of the things that are questionable that she was taken through to explain where did this come from, her answers would be, that's what my investigators told me. And yet here you say that she would have had the benefit of the information note as early as 10 December. Can you just explain how it worked?
I explained earlier in my affidavit, and I'll elaborate now. Advocate Johnson said she was going to be the supervisor of this matter. She was the dictator of this matter. There was not a single move for the period that I was involved, right until 2025, September. There was not a single action that was done in the Medicare or the crime intelligence that Advocate Johnson didn't know about. And it must also be noted that between Advocate Johnson and Mr. Perumal, they would talk to each other and update each other about everything. And that's why I earlier said you could have a conversation with Advocate Johnson and make sense now. And 5 minutes after speaking to Perumal, she's completely changed her mind, and we are now on the beat of what Mr. Perumal wants. So was it Commissioner or Kumalo or Chair that said it's a lie?
I'm just glad it's not me. I'm not in that list.
At the risk of being very badly victimized by when I get back to the office, it's a lie. It is a straight lie. There is, I will demonstrate now, Chair. You a little bit ahead of us.
But I did say, of course, that we are yet to make a final conclusion on the issue. But you as a witness, you are entitled to say it's a lie if you consider it to be a lie.
Am I allowed to say it's a big fat lie?
No.
No. Okay, I retract. It's a lie. I'm going to illustrate now, Chair, you are, but, and Commissioner, you are, but head of us, we are about to show how Advocate Johnson ran the project and gave instructions.
Thank you.
Okay, so we at the premature summonses, that's 66 on page 27. We already looked at the WhatsApp, but you can read the paragraph.
I need to take a deep breath before I read this and we show the WhatsApps, can I?
Yeah, I know, but take your time. It's fine. Are you fine?
I'm fine.
Yes.
Okay.
I know this topic is not an easy one, so take your time.
Thank you, Advocate. On the morning of the 10th of December 2024, 3 business days after the preparatory investigation was authorized, I sent Advocate Johnson a WhatsApp message informing her that I had prepared a summary and a preliminary instruction for the team. I was not instructed to prepare this report. Be that as it may, I asked if I could email it to her for her guidance before sending it to the team. She said that I should, which I did. She did not get back to me on the docket summary until the email aspect, which we'll deal with. Instead, later that afternoon, Advocate Johnson told me to speak to Mr. Perumal because she needed us to do urgent subpoenas on Major General Lushaba's bank accounts before they move money. She said it should be from the time he was acting as divisional commissioner to date. This instruction confused me. I had just sent the docket summary report to her, wherein I stated that there is basically no evidence to support the allegations in the Section 27 referral affidavit. And importantly, I had given strict instructions that no Section 28 summonses should be issued without me perusing them and submitting to Advocate Johnson for signature. I was not sure if you read the report at the time when she had given this instruction.
Well, I think let's just go back. You don't know whether she read, but she certainly responded to your email where you attached the report and said, speak to Chief, because he spoke to the complainant and he'll be able to tell us whether the complainant has the documentation. Your covering email to her didn't give any detail of the docket summary report, so she could have only known that you had an instruction that you must get information and documentation if she had read the report.
I think my statement there is more with regards to the instructions.
The instruction, okay.
Because
Not the
she's automatically overriding my concerns now about 28s being issued.
Or you being generous to her that was in fact the case.
Correct.
That she hadn't read the instructions. But she would have had to, because the information about obtaining the documents was in the instruction.
Correct.
And she's directly telling you in that email that you must speak to the chief because the witness could have that substantiation.
Correct.
Okay, continue.
In any of the documents, and I know you've told us about the Section 27 that you saw, and you've done that table for us. You've looked at the docket. In any of the documents up to this point, had you come upon any allegation that leads to the 50 million rand, let's get his bank account details? Was there anything?
No, Commissioner, nothing, which is why I stated I was uneasy with this instruction. We had authorized, it wasn't even authorized for a full day. We received dockets, I only did the summary on the 10th. And on the 10th, but also my bigger concern was, where did this information, how did this information come to Advocate Johnson? But I will.
Thank you.
Continue, 67.
67.2, she was instructed.
No. 67.1. This instruction confused me.
Yes, this instruction confused me. I had just sent a docket summary report to her, wherein I state that there's basically no
Oh,
evidence.
my apologies, I've been told you did read that, sorry.
Okay.
I'm behind.
Thank you.
67.2.
67.2. She was instructing me to issue Section 28 summonses, notwithstanding my instructions to the investigators not to do so without my perusal. In effect, she overturned my instructions, and this illustrates how Project Diversion was dictated by her and Mr. Perumal. May I continue? 67.3. I could not understand the urgency for two reasons. First, the 2813 was authorized on the Friday, the 6th of December. The dockets obtained on the 9th of December, and my report submitted that day. I could not understand on what basis we could issue summons when we had no prima facie evidence of a crime. Secondly, the urgent summons from bank records would not stop the dissipation of funds in the bank account. What did it matter that the money was being moved? It would have been different if we had
Well, you skipped a
evidence-
line there. The
Oh,
bank
sorry.
records would merely.
The bank records would merely show the movement of the funds. It would have been different if we had evidence that there was an attempt to dissipate the funds and sought an urgent order to freeze the account. If there was a prima facie case, obtaining bank statements on an urgent basis would serve no purpose.
Continue.
I told Advocate Johnson that I would call Mr. Perumal. Before I called Mr. Perumal, I forwarded Advocate Johnson's message to a Signal group chat with Perumal, Padiachi, and Rapesu in the group. Thereafter, I called Mr. Perumal as instructed. He told me that Mr. Rapesu must move fast with the 28 summonses for Major General Lushaba's bank account. He said that Advocate Johnson had received information that funds in the amount of 50 million from the Secret Service account was being moved. As stated above, the movement of funds being the reason for urgent summons for bank statements simply did not make sense to me. But it was clear to me that the decision had been made that the summonses would be issued if both the chief investigator and the head of IDAC have decided that it should be. After this call, I sent Advocate Johnson a message informing her that the Section 28 summonses would be ready as soon as possible for her signature and serviced by Mr. Rapesu. I asked her if he should process it under the Valeria dockets or the Cape Town dockets.
Why did you ask that? Just explain that to us. I just wanted to understand, because you have your own investigation under 2813, why must it be issued under dockets, under other dockets? How does it work?
If I may just refer, I can't remember if the CIN number had been authorized by them
I
yet.
did, yes, that's what I wanted you. There was no CIN number.
If I remember correctly, they hadn't been, it was only later on that a CIN number was allocated to the matter.
And
So
what's
we
the
would not-
significance of the CIN number?
A CIN number is our internal inquiry reference number. We generally don't even use the CAS numbers where they already authorized. But because I didn't have a CIN number, and we were in possession of dockets, but it didn't make sense which docket to use, I had asked her to advise.
Oh, which one should
Which
it be
one
issued
should
on?
we use?
Okay. So if you had a CIN number, that is
The
what?
CIN number would have been used as the reference number.
And when does the CIN number get issued?
CIN number is supposed to be issued on the day that the 2813 is signed.
Can you just raise your voice?
The CIN number is supposed to be issued on the day that the 2813 is assigned or signed off. But if you look at the composition of the team on the 2813 signed on the 6th of December, there isn't a project manager. The project manager is only allocated after everything is done. And that is why I say the whole process of this 2830, using Chair's favorite word, is diyarmakar.
Steer me. Okay. So if there was a project manager, the project manager would have been the one tasked with getting the CIN number and all of that, or what is the?
Correct. I wouldn't, when a project manager is allocated to the projects, as is with most projects, I wouldn't even have direct email with Advocate Johnson. It would go me to the DD or me to the project manager, one of the two, depending on how good you are at formatting your documents. Then from the deputy director to the project manager would then take the documents to Advocate Johnson's PA. And then once it is signed, Advocate Johnson's PA would let the project manager know. He would collect it, he would scan it, and it would be disseminated amongst the team.
Okay, so let's then go to page 171, which is the WhatsApp exchange between yourself and Advocate Johnson. After you say, I will call him now, which is you're going to call Mr. Perumal, which you do. She says, thank you. And then you send a WhatsApp to her after you spoke to him.
Correct.
On page 171.
171. Advocate Johnson, it will be ready for you, your signature, as early as possible tomorrow. The service by Mancha will, tomorrow, and service by Mansa tomorrow. Should we proceed with the Valeria CAS 405 or the Cape Town case? They both have the same A1 and allegations for enrollment purposes. The Valeria would be easier. If I may explain that. If at a given point there was prima facie evidence, to use the Cape Town CAS, we would have to enroll in Cape Town. Valeria is within our jurisdiction, which is why I state same. Her reply, due to the section 28 must use the next number in the register being the CIN register. I was thinking that we call this matter diversion. Then we follow the register, say diversion, and then no one knows what it is, and we are using our systems and process.
Okay, so that is where we get the name Project Diversion from. That's
Correct.
the first time it's mentioned.
Correct.
And did she, other than this explanation, was there ever an explanation, detailed explanation given for the choice of name for diversion? How did you understand it?
Projects that ran out of Advocate Johnson's office, that were not within the projects that ran out of Advocate Johnson's office, that were not within the ordinary SOPs, the ones that Advocate Johnson supervised herself. She gave titles to Matter X, Project Golden. There's even a project, section 41.6, which is she's investigating internal people within IDAC.
What is the 41.6 reference to? Just, I know what it is now, but if you can just say for the benefit of the commissioners.
Section 41.6 of the NPA Act prevents a member or an employee or a service provider or a contractor to NPA from divulging information without the authorization of the National Director of Public Prosecution. It is a certificate that is given to a person where we are, for example, I'm now speaking about WhatsApps, emails that are internal. I had to have a certificate from the NDPP to allow me to speak today. With regards to that project, Advocate Johnson is internally investigating a specific person who will explain. The 2813 days, even, I think if the commissioners and chair had to see it, they'd probably, I don't know, maybe throw a chair. There's no prosecutor allocated to the matter. It is an investigating officer that reports to Perumal directly, and a service provider. So if there's no prosecutor on the matter, who even drafted it?
And this is project 41.6, or, okay.
The reason I'm bringing this up is to illustrate how Section 28 has been abused. And I'm not just talking about 28, 6, and 7. I'm talking about just authorizing investigations. Has been abused for the past.
And that person will be the subject of that investigation, that 41.6. Is it just one person or more than one that you're aware of?
I'm aware of one person being named on as the suspect. But I'm also aware, because I had handed the documents to the DPCI officer through the protected disclosure that I was busy with prior to this happening, that that CIN number was used to obtain bank statements and cell phone records of multiple employees, including myself.
Yes, okay. That will be dealt with by other witnesses, yes. Okay, so we were then dealing with she says it's diversion, and we are using so that no one knows that we are using our system and process, and you say, I will advise the team. Thank you. This is still on page 171.
Correct.
We then go back into your statement at paragraph 69 on page 29.
The following day, 11 December 2024, Mr. Rapesu sent me a WhatsApp message to raise the same concerns I had. I forwarded this message to Advocate Johnson. Essentially, Mr. Rapesu suggested that we stall or park the summonses until we had consulted with the complainant, because his affidavits simply did not set out a case. I paraphrase.
Okay. Before we deal with that WhatsApp of Mr. Rapesu, if we can then go still on the 10th, we then get a response to your docket summary email. Mr. Perumal responds to that, and that is on page 168. I think you send him an email at 11. My mistake, I forgot to mention that at 11:16 on page 169, you send him an email after Advocate Johnson says that you must speak to Chief. You send him an email at 11:16 on that same day saying, hi Dylan, trust this finds you well. Then you can continue from there.
As per trailing, please advise, the A1 indicates that he has sensitive information.
Let's raise your voice.
Sorry. As per trailing, please advise, the A1 indicates that he has sensitive information. After your consultation with him, can you indicate what does he have in his possession that substantiates the allegations? Does he know of willing witnesses? The report in the docket is very vague, but alludes to him having sensitive information to assist with the foundation of the investigation.
Okay, just before you explain this, in the call between you and Advocate Johnson that we played earlier, the recording on the 22nd of July, you say to her, it's all in my emails as to what happened. You can look at, there were emails that were sent on the 11th or the 12th. These were the emails you were referring to?
Correct.
Okay, to say that Dylan had indicated that he had spoken to the complainant.
Correct.
Right. And that, if we go to, because you say to him, you're referring in your message to when you consult, after your consultation with him, suggesting that there's still a consultation to come. But in the call with Advocate Johnson, you were referring to that she had told you that Dylan had consulted with the witness already, and that would have been at the time that you had prepared the 2813, which would have been on the 5th.
Correct.
So he would have, so that you're not referring to here now, he then responds and refers to the previous, to the November consultations.
Correct.
Okay, so if we can go then to his email in response to you on page 168.
Good evening, Advocate Drew. Our earlier telecom has reference. I am waiting for the complainant to confirm his dates of availability so that we can meet with him. He does have documents in his possession, which I understand were shared with him in confidence. I am of the view that we should request same from him during our meeting. He might put us in touch with possible witnesses or sources to further our investigation. I will advise as soon as he returns my call.
Okay, so our earlier telcon has referenced, this confirms that when Advocate Johnson says call him, you called him. That was about the summons, but yeah, you must have spoken about other things as well.
I asked about the documents and the evidence.
Okay, and he's then saying to you, he does have it, so it means that he would have spoken to the complainant before then to know that he has the documents.
Correct.
Okay, and during the conversation with him, did he tell you whether he did consult with the complainant before?
He did. And it would be illustrated in the meeting of the 19th of December that I move on to just now.
Yeah, okay. So in our chronology, this is now the 10th of December, 1939. You have the instruction to do the summons, and on the 11th, you get a private WhatsApp from Mr. Rapesu in response to your signal messages that the summonses must be prepared, the 28s must be prepared.
Correct.
Okay, and that is at 172 now, file 10.
Correct. Good morning, Advocate Drew. I have noted your...
Please raise your voice again.
I have noted your instructions to prepare Section 28s. I was suggesting that we stall or park it until we consult with the complainant. The reason being that his affidavits are not drafted properly. We need to consult with him so that we may be in a better position to do same. I'll prepare them in the meantime so that after consultation, we could move faster. I then...
Okay, you then forward that to...
Advocate Johnson.
Okay, you can read that message.
Morning, Advocate Johnson. A suggestion sent by Mansa. I will await your instructions. I specifically put in there, because I've already expressed my unease about these things. I specifically say that the consultation is set for the 19th of December in Gauteng, GP.
This is the consultation with Mr. Adams.
With Mr. Adams.
And why are you putting it in there?
Because I wanted to know that we are now on the 11th. On the 19th is when the consultation is going to take place. So that even what Mr. Rapesu is saying, that after the consultation, we can move forward with them, but at this point in time, we don't have enough. I was also trying to illustrate that it was only an 8-day period or difference between serving the 28s now for the bank accounts as compared to if we consult with the complainant and get better details to justify serving these.
Just a moment. The affidavits referred to by Mr. Mansa, are these the statements in the docket so that we don't confuse them with the Section 27 affidavits or the later A1s? Because those came in January 2025. So when he says his affidavits are not drafted properly, what are the affidavits that he's referring to?
He would have been referring to the affidavits, the A1 affidavits in the dockets.
In the docket.
Because I had made copies
Yes.
for all parties concerned, so that they could follow as to what was happening. And it didn't make sense for the originals to be there and them not to have copies of them to work off. So they had copies of those things.
But he's not referring to the Section 27 affidavit?
No, Commissioner, he's referring to the affidavits in the dockets, the actual dockets.
Okay. And then we can then go so you're saying to her the consultation is set for the 19th of December. Mr. Rapesu suggesting that we park it just for 8 days. Let's consult with him effectively. That's why you're telling her that it's on the 19th.
Correct.
So we can go back to your statement at paragraph 70 on page 29.
When I forwarded the messages to Advocate Johnson, I also said that this was the suggestion from Mr. Rapeso and that I await her instructions. I also informed her that the consultation with the complainant was scheduled for the 19th of December 2024 in Gauteng. I had hoped that the fact that the consultation was the following week would persuade her to pause the Section 28 summonses in line with Mr. Rapeso's suggestion until after the consultation. Paragraph 71. However, she responded that she had her reasons for the summons and that she was going to discuss it with us. She was going to discuss it when we, Mr. Rapeso and I, go to her with the summonses. May I just explain?
You can go to the WhatsApp and then you can explain as well. So the WhatsApp is still on 172, where she says, you say consultation set for 19 December in GP. A response?
I have reasons to ask for the summonses, which I was going to discuss with you guys when you guys came with the summonses. Please prepare so long, and if you guys still feel like putting it on hold after talking to me.
I think it's cut off. I think the last thing says, then it's fine.
Yeah, then it's
we'll
fine.
just get that last one. It seems to be missing from the bundle.
If I may just explain.
You can explain if you promise to raise your voice.
I promise to raise my voice. I apologize, Advocate. The process for 28s is not that the prosecutor takes it. Usually it's the project manager, but like I explained, with projects run out of Advocate Johnson's office, it's a different procedure. But the 28s, because it would have come to me to approve what was being requested and all of that, it would then be taken by the investigating officer to Advocate Johnson. So that message where you guys come to sign doesn't make sense, because I probably wouldn't have been there if I didn't have, or the normal process of it I would never have been there to sign at 28.
So the project manager would get her to sign it.
The project manager would leave it with her personal assistant unless it was urgent, then they would go to her.
But now she's telling you to have it ready, but she's still open to a discussion. And you understood it that way?
No.
Okay.
If you're saying prepare them, and because I've worked with Advocate Johnson for such a long time, Advocate Johnson and Mr. Perumal had already decided that those summonses were going out. We were just being placated.
And was there a project manager here
At that point, there was no project manager.
for this?
If I'm not mistaken, and I stand to be corrected, I will, in part 2, deal with that. The project manager comes on board around February, March.
Okay. Thank you.
Okay. We can then go to where we're at, paragraph 71. She told me to prepare the summons in the meantime, and if we still felt that it should be put on hold after talking to her, she will be fine with that. You can continue then on page 30, the second sentence. This message.
This message was already confirmation to me that the summonses was going to be issued by Advocate Johnson, whether we liked it or not. She told us to prepare the summonses because she knew she would not take no for an answer when we met with her.
Can continue.
Prior to this exchange, in respect of Mr. Rapeso's suggestion and in the response to my messages as to whether the summonses must be issued under the Valerio Cape Town docket, Advocate Johnson responded that I must do 2 summonses, and then she referred to the project for the first time as diversion. She said it would be called diversion, then no one would know what it is, and that we were using our systems and process. None of it made sense.
Okay, then on the 12th.
On the 12th of December 2024, Mr. Rapeso and I, with Advocate Johnson, met with Advocate Johnson regarding the summonses. As she had suggested, there was no discussion on the summonses as predicted. Advocate Johnson gave an instruction to serve summonses because she had information about 50 million rands, and that we need to stop it from being moved out of the account. Mr. Rapesu complied and sent the summonses to me. His annoyance is noted in the title of the email attached to the summonses.
And I think we must go to it at 173. Mr. Rapesu is also the person in the voice note that said they jiggered the signature. You'll recall that, he said. So he sends the email on 173 on the 12th of December in the afternoon, 15:32, to Mr. Perumal, yourself, and he copies Mr. Pariachi, and the subject says?
Summonses what?
Yeah, section what. And he attaches them.
Sorry, you all spoke at the same time. Please just reread it.
Section what?
And he then attaches you can go to 174, those are all the section 28 summonses that he had prepared and that Advocate Johnson signed. So if we can then go to 175, that's where we see one of the summonses that had been prepared and signed by Advocate Johnson. Are you there?
Correct.
It's got at the bottom of the page, it's got inquiries, Mr. Rapesu. Do you see that?
Correct.
What I want to show you is on page 176 under background. If you can read background into the record for us, please.
The information required from you relates to the conduct of an investigation into serious, high-profile or complex corruption within the South African Police Services, authorized by the investigating director, who is the head of the investigating directorate, in terms of Section 28(1)A of the NPA Act, into allegations of the commission of the following offenses: fraud, corruption, defeating, or obstructing of the administration of justice.
Just the reference to 28(1)A, on some of the other summonses under the preparatory investigation, it specifically says 2813. This one says 28(1)A. Was it used interchangeably? Because it does seem to me that on this one, and I think you've been given a copy of the Act, if you go to 28(1)A, is if the investigating director has reason to suspect that a specified offense has been or is being committed, or that an attempt has been or is being made to commit such an offense, he or she may conduct an investigation on the matter in question, whether or not it has been reported to him or her in terms of Section 27. And then B says if the national director refers a matter. So, and then it says the investigating director shall conduct an investigation or a preparatory investigation as referred to in subsection 13 on that matter.
Correct.
Now here there's reference to 28(1)A, and we understand that we had, here there was a 2813 investigation, it was a preparatory investigation. Do you understand 28(1)A reference here to be something other than a 2813 investigation?
I did not peruse these documents before they were disseminated. After that meeting, went home. I advised Mr. Rapesu he has received his instructions from the ID. I had addressed his concerns. He had received instructions from the head of office, and I then distanced myself from these 28s, because how were you going to explain this at court? And who was going to explain it at court? And so I think that question is best reserved for Mr. Rapesu.
Yes, but he would have known that it's a 2813.
Correct.
Okay. I just wanted to know if there's a distinction, because some of the summonses specifically say 2813, and this one that it says 281A. So that's why I wanted to know whether there was a distinction.
I think maybe he would be able to answer as to why it's 28-1 versus.
Okay. Do you know whether, so you guys went with hard copies to her office for her to sign on that day?
Correct.
So he would have prepared it?
Correct.
Okay.
All you have at this stage are the dockets and the section 27. How do the two of you know that General Lushaba banks with Bank A and that it is Bank A that you must subpoena for his bank statements? Where does all that information come from? Because if it was a subpoena to subs, everybody knows that a general is employed by subs. But once you issue a subpoena to a bank, it means you must know that Kumalo banks with that bank, and that's the person we must issue a subpoena to. Because this is still the 11th of December. If there's a weekend on the 7th and the 8th, the dockets only came in on Friday. So 2 days later, and this information is not in the dockets. What's going on here?
It was another pink note on another piece of paper.
It was on the pink note.
On another piece of paper.
Another one, not the original
Yeah,
one.
with handwriting.
Yeah,
But I
you just
think-
need to raise your voice, but
I
can I
think-
just say
yeah.
before you say that, it is something that was going to be covered by Mr. Rapesu, but you can deal with it because it happens in your presence on the day when Advocate Johnson tells you to come to her office. So you can deal with it.
May I explain the meeting on that day with
Yes.
regards
Do
to?
you want her to deal with it in detail or to only summarize it because you say Mr. Mansa is going to deal with it in detail? How do you want her to
His
deal with
intention is to deal with it in detail, but to the extent that Ms. Ramsamy was going to corroborate his version, I guess she can deal with it
Because
briefly.
I was happy with the answer that it was in a second pink note. That's where the information comes from.
Yes, so the evidence is that it was, all the banks were being used, but there is, if you go to page 177, and it should be, there's personal detail on there. On 177, can you see his name and then ID number? So perhaps you can explain where they got that from.
The pink note with the handwriting, the pencil handwriting.
And it
That was
came from Advocate Johnson.
correct.
I think we can.
Okay.
And it was her writing.
Yes, it was high.
Which was given in that meeting.
Correct.
Okay. But maybe just tell us the process, not from Mr. Rapesu's point of view, but from your point of view. He has the prepared documents, but he doesn't have the annexure B, which has that detail on.
Correct.
He gets given that detail in the meeting.
Correct.
Okay. Thank you. And do you know more or less what time that meeting was? Because his email attaching the section what is at 15:32 on that day.
We were called in at about, I think it was either 10 to 3 or 3.
Okay.
Yeah.
So he had it, and then but insofar as Annexure B is concerned, when would he have done that?
Maybe I'm getting my timelines. I cannot remember because we went in, the meeting wasn't even that long. It was maybe 5 minutes. Paper is given. Mr. Rapesu goes to his office because the investigators share an office on that end. Prosecutors are in the open plan on the other end. And it was home time for me, so I left.
Okay, thank you. Then we can go to your next, page 30 of your statement, the confidential crime intelligence documents, paragraph 74.
Let's adjourn for what? We'll indicate when we are ready.
Thank you, Chair.
Let's adjourn.
All right, we are ready to resume. Please make sure that your cell phones are off. Thank you.
Yes.
Thank you, Chair. Put on your, and raise your voice.
Yes, ma'am.
Let's, page 30, and we are starting a new topic, but it's a short one. The confidential crime intelligence documents, paragraph 74.
Thank you.
Before you do that, let me put this, whose answer may be obvious, but let me put it to you and for your comment, if you want to. With this summons, the 50 million rand summons, we know it's not in the section 27 affidavit
Correct.
that you have seen.
Correct.
And it's not in the one that was flighted here, that is dated November. We know that.
Correct.
And it's not in any of the A1 statements, and there's no affidavit, at least before us yet. And you say earlier that it's nowhere, it's not in any documents. It seems to me, and this is what I want you to comment on, it seems to me that either Advocate Johnson or Chief Perumal, because they're the two people that you say were intimately dealing with this, the two of them would have or must have received information, if they did, about the 50 million rand. It's about to be moved from a secret service account. That, and they have a list of bank details of General Lushaba, that kind of information, if indeed they had it, would have had to have come from someone at crime intelligence, because we are talking about funds being moved from a crime intelligence account. Is that a fair summation?
It's the same conclusion that I came to.
You drew that
I
conclusion
drew the
too?
same conclusion.
Okay.
That because upon discussing, well, I had drawn that conclusion from the prepare it. In the meantime, I have my reasons, and from the conversation with Mr. Perumal, saying that the ID has received information. And when I had discussed it prior to going into Advocate Johnson's office with Mr. Rapesu, Mr. Rapesu asked me, and I said to him, you are now placing me in a very difficult situation, so can you please ask the ID in the meeting? He asked me if he gets asked about this 28 and why it was done so prematurely and on what basis, because he, and so was I, of the opinion that it was unlawful to proceed with the 28. He said to me, is she going to come and testify that she received the information? Is she going to file an affidavit that she received the information? So there was a lot of discomfort and annoyance about this whole instruction.
And to your knowledge, did anything further happen about this 50 million rand investigation, if it was an investigation? I mean, we see in the summons, she says that she has authorized the section 28(1)A investigation. So let's assume for present purposes that's what happened. Did anything further, to your knowledge, happen about this part?
Prior to me being removed, there was a lot of distrust, discord. As I stated before, if you went against what Perumal was wanting to do, you were attacked by Advocate Johnson. So at that point, I was currently at the target. I was literally the bullseye for that attack. And in a meeting, I had asked specifically, what has happened with those? And because I knew that Advocate Johnson had given instructions to the whole team that once it's received, it must be given to the financial investigator, Mr. Venan, that was designated on the matter. So in April, and if memory serves, it was in the meeting of the 24th of April, 2025, Yes, it was. It is in the notes. I had asked what was this about? And where are we with this investigation? What has been done? To the extent that Venant had not been given the USB. Perumal denies knowledge of the 28s being done. I had to file a subsequent affidavit as a prosecutor for one of those internal investigations that I explained earlier. And in that affidavit, it is part of part 2. It explains how angry I got that it had not been handed over. When it was handed over late September, just before I got removed from the matters, I think it was it would have been August because I was removed on the 2nd of September last year. Venant indicated that he found 3 suspicious transactions, but he was still investigating them. There was no conclusive proof, and they were 50,000, not 50 million.
Thank you.
Before we get to 19 December, you mentioned the name earlier. I think you were responding to one of the questions. In our engagement with Advocate Johnson, the first time we see that name is the 29th of April, 2025. It's the name of General Matlo, who's the head of risk at SAPS. But earlier in response to a question, you said something along the lines that somebody said in December, speak to General Matlo or General Matlo will provide the information. How does she come in? Because at this stage, there's no affidavit from her, there's no section 27 from her. How does that name keep coming up, especially in December 2024? Can you just clarify that before we go to the crime intelligence documents?
I'm going to give a comprehensive explanation. General McClough is a witness on many matters within the IDAC. Okay. She has a very close personal relationship with Mr. Perumal. He's also former SAPS. But on the 6th, when I asked Perumal, where do I get the details for Lieutenant General Kumalo, because I didn't even know his name. He said to me, no, don't, hold on, I'll speak to Charity, and that's how the
You mean Major General, not Lieutenant?
Yes,
Major
Major
General.
General. I get confused with the titles, sorry. He contacted her, and that's how I got the details.
And so you did not speak to her, he contacted her?
On that particular day, no, I did not speak to her.
So you had no interaction with her throughout December 2024?
During December 2024, no, I had no. My interactions, once again, with General Matlo would come into part 2, starting
Then let's leave it
Feb,
for part
yeah.
2. Thank you.
So, still on the summons, before you go to 74, insofar as the summons, and I'm looking at Annexure A at page 176, where it says the ID has authorized an investigation in terms of section 28(1)A. Can we, at least with you as well, confirm that as of the date of this summons, which is December 2024, there was no decision yet in terms of 28(1) in respect of these crime intelligence matters?
Correct.
Okay. So there was no such investigation at this point that has been authorized. And what is the formality or the formal evidence of a decision of the ID that now I'm authorizing an investigation in terms of 28(1)? What form does it take? Is it in writing? Is it a certificate? How do we know that?
It has to be an application form.
Yes.
The application must then set out comprehensively, as I dealt with earlier in my statement. it has to set out the evidence in each statement or how the evidence collectively obtained speaks to each offense or element of the offense that we are alleging. We would then do a breakdown. It is in part 2 where we would do a breakdown of A1, Mr. Adams. It's late in the afternoon. Mr. Adams. And then I would say what he says in his, I would then also put the possible problems and which of the offenses it relates to. And then I would go on and on and on as per the evidence collected.
So the point is there will be a document which records the decision itself, the decision to conduct an investigation.
Correct. It should be done that way. The 28 ones that I had authorized all came with evidence reports.
Okay, thank you. Lastly, before you go to your paragraph 74, it's about that 2813 that you
Yes,
prepared. And I just want to check that maybe we made too much ado about nothing with Advocate Johnson. Now, that document, you remember it starts at 106, 107, 108. It's that one that has the names that she didn't remember where she got the names from.
Correct.
Now, if you look at 109, the foot of that page, it gives you the date and signed where. And then the next page at 110, it has Ms. Johnson's details. And it didn't make sense to us that she would have written a 2813 to herself, because we have a document that doesn't indicate who is the author. On the front of it, it had said, I think, that it's written by you and somebody else. But then you get the signature page at 110 when we expected that there would have been where somebody recommends and then where an indicator where she approves. And she was challenged on it that this looks like she wrote this for herself. She prepared it. Do you care to explain what happened here?
Can I go back to the flip-flop situation?
Yes, you can flip-flop.
No, I'm not flip-flopping. I'm going back to the nickname.
Yeah, you may.
Okay. If we go to the 2023 authorizations, you would see it would be
2023 referral that you worked
that I
on.
dealt with, yes.
Okay.
So it would be a recommendation by Mr. Sissoko after perusing all our documents, and then an authorization by Advocate Johnson. Later on, it was changed to, it has to be signed by the DD, Deputy Director, and then, recommended by the Deputy Director and authorized, and then Mr. Sissoko was removed. Later on, it just became Advocate Johnson that signed. And then why I say flip-flop is because when the Medicare 24 was done in 16th of May, 2025, so I did it exactly like this because I will explain why. I was called by the PA to come and add my signature. And then Advocate Johnson's signature went there as recommended. So like I said, it was a flip-flop situation where one day we did it like this and the next day we were told remove it. And it was throughout the office in that way, to a point where Mr. Sissoko has been made redundant with regards to signing or approving documents. He doesn't even see them.
So here what would have happened is you prepared the document, you didn't sign it, it doesn't have provision. As you prepared it, there was no provision for you to sign, a provision for you to sign. It only provided for her to sign. Okay. Thank you.
Okay. Page 30, paragraph 74, the confidential crime intelligence documents.
Thank you. Paragraph 74. On the 19th of December 2024, the team was scheduled to meet with Mr. Adams. However, Mr. Perumal stated that there was a miscommunication and Mr. Adams was at Sun City Resort. I refused to travel to consult at that venue. Arrangements were then made to meet in Cape Town on the 6th of January 2025. In the meantime, on the same day, Mr. Perumal and Rapesu and I met at a spur in Midrand Halfway Gardens regarding the confidential documents that Mr. Adams alleges was pushed under his door. Mr. Perumal was to provide me with the documents to peruse. First, the documents related to crime intelligence. If it were up to me, and I did say so during the consultation with Mr. Adams, I wanted to charge him. I also wanted an explanation from him as to what did he do with the documents.
This is now
after
in
receiving-
January, not...
Yeah, sorry, Afghan.
You're moving ahead.
I am. First, the documents related to crime intelligence. If it were up to me, I would have considered charging Mr. Adams for possession of these documents. In the bundle of documents were 74.1, receipts of a forklift in respect of which payment has been made, a copy of the internal vetting report of Major General Mudondo. This was particularly concerning to me, and I voiced this discomfort. May I explain why? A vetting document, I think most of us here would know, contains your address, your ID numbers, the ID numbers of your kids, your spouse, your banking detail, and this document is the school that your kids go is now slotted under someone's door and they are in possession of it. It was very concerning, the amount of information that it had. 74.3. A statement from either Mr. Pinar of Crime Intelligence or a Mr. Van Vieren. I'm not sure if it was a Mr. or Miss, but it was either Pinar or Van Vieren. I cannot recall the name. Relating to Lushaba's housebreaking and the involvement of the vetting unit. 74.4. Media articles about Mr. Lushaba's housebreaking incident. 75. These are the documents I recall because...
The only documents I...
Sorry. These are the only documents I recall because I saw those documents once on that day and never again. I perused the documents and asked Mr. Rapesu to take notes. The documents appeared to identify possible witnesses and suspects. However, the names in the documents did not correlate with the list of names that Advocate Johnson gave me on the 5th of December 2024.
Not correlate entirely, because there were some that did.
Correct.
Okay.
Did not correlate entirely.
Okay. Then 6 January 2025, consultation with Mr. Adams.
Thank you. Paragraph 76. We all went on our annual break, and on our return in January 2025, Mr. Rapesu and Perumal and I went to Cape Town on the 6th of January 2025 to consult with Mr. Adams. We met Mr. Adams at the Cape Town DPP's office. I questioned Mr. Adams about how he came into possession of the crime intelligence documents and what he did with the documents from the time he had received them. He said that he had retained copies and given the documents to Mr. Perumal. He stated that he reported the incident to the Police Portfolio Committee and was shut down by Mr. Ian Cameron, the chairperson of the committee. 77. Thereafter, we informed Mr. Adams that his A1 statements in all the dockets would have to be supplemented because they were wholly inadequate. And what was required was actual proof of the allegations contained in his A1 statement, the Section 27 referral and the Section 27 referral affidavit. We proceeded to draft the affidavits, and if I recall correctly, Mr. Perumal typed the supplementary affidavits, and I was assisted by a prosecutor to print the affidavits, the prosecutor being part of DPP Cape Town.
Can I ask a question? You obviously spoke to Mr. Adams on the 6th.
Correct.
Did he explain to you how the documents, because you say you wanted to charge him for that, and if I remember correctly, the suggestion is that somebody slid the documents under his door at the offices in Parliament. Is that possible? I mean, does that story make sense to you? Because if it did, then they would have fallen into his lap, you know. It's not as if he was in possession of them. If somebody dropped classified things on my desk, they are there.
May I, from my consultation with him, explain why I agree with the commissioner? When I was consulting, I was explaining to him, you are in possession of these documents. What did you do? You know that process. And I said to him, do you understand this is a criminal offense? And he said to me that it was slotted under his door in an envelope. And then I said to Mr. Rapeso, we are in Cape Town. Well, actually, I said it to Mr. Rapeso and to Mr. Perumal, because they were sitting on their own and I was on the other end of the boardroom. So I said to them, okay, we're in Cape Town. We can go to the parliamentary building and go and get the video footage. Also, we can get the register of who signed into that building on that day. And Mr. Adams' reply was, there's no cameras on that in his corridors where his offices are, and I find it very strange. And then with regards to the register, Mr. Perumal told me it will be futile because of how many people sign in and out. So yes, I did draw the same conclusion as the commissioner, that this could not have happened.
I mean, if somebody left classified documents on my desk and I happen to open the envelope and I see that they are there and I report the matter to IDEC, why would you charge me for that? Because I found them there. It's not as if, you know, I acquired them through some improper means.
Commissioner, we must look at the timelines, and that is what I questioned about. I questioned, you received in September under your door. You opened your cases at the end of October. You refer to IDAC middle end of November. That's a very long time to be in possession of those documents.
It means he had them with him for at least 2 months before
Correct.
he came to IDEC.
Correct. The other concern is that when you were opening the dockets, if you didn't want to give the original of the documents that was slotted under your door, why not make copies, have them certify it, and attach it to the A1?
I
In the
assume
dockets.
he kept them with him even after the Section 27 referral to IDEC. He did not give them to IDEC.
Yes, well, the information that was relayed to me directly by Mr. Adams and confirmed by Mr. Perumal, and it is in the recording that I have provided. It's just a very lengthy recording. I recorded the entire consultation with Mr. Adams. When I start asking Mr. Adams, where are the documents? He said, no, I kept copies, but I'd given the documents to Dylan. And Dylan confirms, yes, no, we have them.
And it's Perumal.
Perumal.
Thank you.
The affidavits obtained by you and your colleagues are very terse in content. What is that a function of? Why is that so? I do not find them to be better than which affidavits? The A1.
They were not. They were still futile.
Why is that so?
Because he didn't have anything further than what was slipped under his door.
Mr. Adams could not
He could not supplement.
give any useful substantiation?
Nothing.
All right,
Okay, back to your statement. 78.
Thank you. Thereafter, Mr. Rapesu commissioned all 4 supplementary affidavits. Those 4 supplementary affidavits were the only affidavits commissioned in my presence in Cape Town. Mr. Perumal did not commission any affidavits in my presence. I do not know when he would have met with Mr. Adams that day to commission any other affidavits. More importantly, I do not understand why the same witness would depose to a main affidavit being an A1 on the same day he deposes to a supplementary affidavit.
Continue.
But it also seems, isn't it, a misnomer to call the Perumal affidavits A1s, because in the docket you already have A1 statements.
You could never do that. It would
Yeah.
never, and it can't be that it's mismarked because the Mukwela docket is an A1.
Yes,
And when we were in Cape Town, there was no Mukwela supplementary taken.
yes. Thank you.
Can you just deal with this issue?
Yes,
The
Commissioner.
3 of you are in Cape Town.
Yes, Commissioner.
Together, statements are being prepared. Did Mr. Perumal have his Commissioner of Oath stamp with him in Cape Town? Because the other affidavits that we have seen, and they were commissioned on the 6th of January 2025, they bear his statement, and he's the Commissioner. Stamp, sorry, not the statement. His stamp is used to commission those statements. Did he have it with him on the day that the 3 of you were in Cape Town?
Commissioner?
And would he ordinarily carry his stamp around?
No. None of the investigators generally carry. Also, the Pretoria stamp will be futile in Cape Town. But on that day, Mr. Perumal had no stamp and he commissioned no statements. That is why I sent the voice note that I did. I think it was on the 22nd or 23rd.
So what conclusion must we draw when we see affidavits commissioned by him on the 6th of January 2025? Subject to him coming to explain, of course. But because you are here and you were with him that day, what conclusion do you say we must draw?
The exact conclusion that Commissioner Kumalo used on that day. Those statements are doctored.
Don't think that came from me, but I'll take that.
It was you, Commissioner. I remember specifically, I was watching and I'm like,
Are you sure it was not Advocate Silla?
Advocate Silo is very nice compared to you. No, it is the conclusion that the commissioners can draw. Also, I can attest, and I'm under oath, and I have freely provided the evidence in the 27 referral that I saw. It says a lady. We didn't even know the name of Mukwele when we went to Mr. Adams for those supplementaries.
Did he know the name? Did Mr. Adams know the name?
If he did, he didn't mention it. It was the Mukwele name was never mentioned.
In the voice note that you sent, and now, you say that Mr. Perumal did not commission any statements. Can we, for the record, now that you're sitting there, just confirm that you were with Mr. Perumal the entire time that you were in Cape Town until you departed, and did you depart together? And you confirm that there would have been, forget that it doesn't make sense that a witness on the same day would do an A1 and a supplementary arising from the same consultation. Forget that for now, for the purpose of my question. But there was no opportunity that you could have missed where Mr. Perumal, after all, commissioned a statement.
Except for my 1.5 hour to 2 hour nap on on the 6th, because we flew at 4:30 in the morning. I was very tired. So except for that nap just before dinner, we were together. In fact,
Magic hour.
how would he have traveled? How would he have printed? These are all the things that played on my mind when I saw it flighted, and I was like, how did I miss this? Because in part 2, I did miss it in June when I saw the affidavit. I did. I missed it until it was flighted. But that is for a different reason that I missed it. My questions then would be, we had one vehicle. Mr. Rapesu was the designated driver. He had the vehicle keys. Except for that few hours, we were together. So, and even if, let's say hypothetically, Mr. Adams came to the hotel, where would you have printed it? We didn't even have a business center at the hotel we were staying in. Where would you have the stamp?
I have printed documents at a hotel.
Did you have your stamp? Because if he had the stamp, obviously it would have been produced when we were at the boardroom at DPP's office.
What you're saying is, but for that 2 hours, 1 to 2 hours that you took a nap, there was no opportunity for Mr. Perumal to have sat down, taken a statement, and then got it commissioned.
Commissioner, even if it was the next day, because we did have other meetings, we decided to utilize the trip. So we have another matter that we were investigating. And I didn't know that the ID didn't authorize a consultation with the attorneys. I only found out when I got to the consultation, because Perumal had told me the night before that we were going for this consultation. It was the 7th of January. So in that time where I was busy, I had a lot of other work and a lot of other things that I needed to do. So I used that time. I sat at the pool with my laptop and I was busy. So even in that time, it would not be the 6th, it's the 7th.
Thank you.
Advocate Ngube, just a moment. This is important because when Mr. Adams gets here, we must put some of the questions to him. Commissioner Baloyi mentioned the happy hour and the possibility that during that happy hour, a statement could have been taken from Mr. Adams and commissioned. Would it have been proper, seeing that the three of you traveled together, would it have been proper for Mr. Perumal to consult with Mr. Adams separately and take a statement and commission it in your absence and Mr. Mansa's absence?
No, it would not be. It would be irregular.
Yes, and then you were still, although you were no longer part of the case in October last year, when the issue of disclosure of the docket to the accused was being discussed, remember there was a discussion with you about the Section 27. Now the supplementary affidavits that were disclosed to the accused, was it the Perumal affidavits or the affidavits that the three of you took, the four that you took in Cape Town when you were all there? Which ones were disclosed to the accused?
As far as my memory serves, and I've got the USB here, as far as my memory serves, I didn't see Rapesu's supplementary in the disclosure that was given to me by the team.
So the disclosure given to the accused, remember when the docket is disclosed to the accused, which sets of affidavits? Was it the affidavits that you were aware of, or was it the ones that Mr. Perumal commissioned?
When disclosure took place, and when I saw the flighted, and then when I went to the USB that was disclosed to me, which is the same copy that was disclosed, it's the 6th of January, 2025, commissioned by the schizophrenic affidavit, the Pretoria, Cape Town, Dylan Perumal.
It's the Perumal affidavits that were disclosed to the accused. Isn't that improper because it means incorrect affidavits are disclosed to the accused and not the original affidavits that were taken from the witness?
I would say that the commissioner is being kind. It's unlawful. It is unlawful. It is unlawful. It is not irregular. It is unlawful. It is an offense.
And then you mislead the court when you say to the court a full disclosure of the docket has been made to the accused, when in fact that is not the case.
Correct. And you're supposed to, by law, even if it doesn't support the state's case, you're still supposed to disclose. Because we are not persecutors, we are prosecutors. Our job is to present the evidence for the court to decide.
I just wanted to say, a person who does that just to avoid the you, there just might be people who might understand the you as referring to you.
I meant IDEC, sorry.
Take no
I didn't mean you
offense.
personally, I meant IDEC.
You say it's unlawful. In fact, your code of conduct says you must disclose even material that assists an accused person.
Correct.
That is in your possession.
Correct.
Yes. You said something about the disclosed docket. When it was given to you, you don't recall seeing the Rapesu affidavits, supplementary affidavits. Ordinarily, you as the prosecutor in this team, what role do you have when it comes to the disclosure of the docket? Do you look through it? Does it get given to you? Do you have any role whatsoever, even if it's a passive role of it does get given a copy?
May I explain Perumal's team and disclosure versus IDAC at disclosure? Even the prosecutors don't get given the original dockets.
What Perumal's team we're
Perumal's
talking
team.
about? Okay.
We get given scanned copies of the docket. We have to work off scanned copies of the docket. Advocate, may I? So even when you're drafting, you would work off the scanned copy that they have given you. You don't have the physical, which is not proper. You're supposed to have the physical docket. You're supposed to, in the DPCI matters, we do a thing called docket audit, where if we're disclosing electronically because it's thousands and thousands of pages, or maybe just 500 pages, or whatever, we would sit with the investigating officer and the prosecutors, and we'd go A1, check, A2, check. That process, whenever asked for by Perumal's team, is bypassed. And the reason I'm bringing this up is I recently did a memo saying that charges must be withdrawn on another matter. Because when myself and my co-prosecutor, after numerous emails and numerous fights, finally got the A, B, and C clip, we found exonerating evidence in the C clip.
This is after disclosure of the docket.
This is when I set the matter down for trial.
Okay.
So I did a memo, and I still haven't received a reply from Advocate Johnson, stating that, one, because of this evidence. So the prosecutor and I then embarked on our own investigation. We went and checked. We confirmed with the witness. The witness then emailed us another supplementary affidavit confirming that the investigators didn't ask about these things. We attached all of that, and we did a memo saying this matter needs to be withdrawn. So and I explained it earlier, so Advocate Johnson calls Perumal's team the A team, and then there's IDAC. So the A team, they don't follow the rules. And that is why we did not, I still haven't seen the physical docket.
Thank you. Lastly, on this disclosure issue, is there a rule in IDEC about the disclosure of the Rule 27 affidavit?
The referral.
The referral, rather. Is that part of, as a matter of rule, It may be that it's not complied with. I'm asking that kind of question, whether there's a rule or it's as you deem fit. About that referral, is it part of the docket? Does it get disclosed?
Advocate Johnson's instructions is a 27 referral does not get disclosed. However, I am aware that a legal opinion on this has been sought. We haven't received it yet.
Receive the opinion. And is there a reason that has been offered by Advocate Johnson why you wouldn't? I mean, intuitively, it seems the source of the complaint, which is an affidavit, would be part of what? Would be part of your docket. Is there an explanation or justification that has been given for non-disclosure?
Commissioner, when I brought this up in 2023, I was shut down as it is just not. There's no explanation. It is, I said, and that's it.
Thank you.
And I think you said you consider the Section 27 affidavit to be an A1.
Correct. It should be the A1 because it is the founding document to a docket and investigation, or an investigation leading to a docket, whichever comes first.
But in this instance where you have dockets that were already existing before the Section 27, could there be some justification as to why it wouldn't be considered as part of disclosure because you already have 4 A1s in existing dockets?
To answer your advocate, if the A1s had sufficient evidence, it could have maybe been justifiable. But because the A1s didn't have any substance, it should have, in fact, that should have been the supplementary, the 27 referral.
Okay. Can we then go back to your statement, paragraph 79?
As an aside, I recall that during the meeting, Mr. Adams showed us messages that he had received from either Minister Mkunu directly or from Mr. Cedric Nkabinde. I cannot recall. These messages were allegedly from Lieutenant General Mkwenazi from the PKTT. I did not
About the PKTT.
Sorry, about the PKTT.
Read that sentence
Let me
again.
read that again.
Just start the paragraph again, as an aside.
As an aside, I recall that during the meeting with Mr. Adams, showed us messages that he had received from either Minister Mkunu directly or Mr. Cedric Nkabinde. I cannot recall. These messages were allegedly from Lieutenant General Mkwenazi about the PKTT. I did not read the messages. I frankly was not interested. And I just handed the phone back to Mr. Adams.
Can you tell us what Mr. Adams said the messages were about?
Mr. Adams said that the messages were Lieutenant General Mkwenazi threatening to arrest Minister Mkunu if the PKTT was shut down.
And this was on 6 January 2025?
Correct.
Okay. You didn't see the messages, it wasn't something that interested you?
No.
Okay. Then paragraph 80.
The events that follow after 6 January 2025 were even more concerning, which I will deal with in my second statement.
Chair, as indicated, the witness is going to testify in 2 parts. She's still in the process of finalizing the second statement. We would ask that her evidence be parked until Tuesday for her to finalize that, be interposed by a witness tomorrow, potentially 2 tomorrow, along the same stream, the IDEX stream, Chair.
Thank you, Ms. Sigels-Ncube. Thank you, Ms. Ramsamy.
Thank you, Chair.
The hearing of your testimony is postponed to 9:30 on Tuesday.
The 4th.
18 date, 4 August 2026. Let's adjourn and resume at 9:30 tomorrow.
Thank you.